Dr. Vijay Munot, the principal of the Swatantya Senani, Jawaharlal Darda College of Law, Yavatmal. Dr. Sandeep Nagarale, sir, the coordinator of IQAC, SSJDCL Yavatmal. The faculty members and all the esteemed participants. Today is the 8th day of the ongoing certificate course on research methodology, which is being jointly organized by the IQAC, Swatantya Senani Jawaharlal Darda College of Law, Yavatmal, and the Department of Law, Manipur University. As usual, today also we will be having 2 technical sessions, as it has been reflected in our schedule. Our first resource person is none other than Professor Dr. Azim Khan B. Pathan, who is the Dean Faculty of Law, Kalinag University, Naya Raipur, Chhattisgarh. And Sir will be delivering his lecture on the topic research methods and doctrinal research, which indeed will be a very great learning for all of us today. And in the second technical session, we have Dr. Payal Thaorey, who is the assistant professor at RTM Nagpur University, Dr. Babasaheb Ambedkar School of Law, Nagpur. And Madam Payal will deliver her lecture on the sampling, data collection, and processing. I believe till today, the journey of each one of us in this course has been very meaningful. And I once again thank you all the participants for showing your enthusiasm in continuing this program and continuously supporting this program also. And on this note, I would like to invite Dr. Vijay Munot, Principal SSJDCL, to present the welcome address and give a brief introduction of our resource person of this first technical session.
Thank you, madam.
Welcome, sir. Welcome.
Thank you. Good morning to all. On behalf of Swatantya Senani Jawaharlal Darda College of Law and Department of Law, Manipur University, it gives me a great pleasure to extend a warm welcome to everyone gathered for the 15th session of our certificate course on research methodology. Today's session focuses on a vital and foundational topic in legal research, that is research method and doctrinal research. In legal scholarship, selecting a appropriate research method is crucial because it is determination how one frame questions, collect evidences, analyze data, and draw conclusion. Doctrine. Am I audible, madam?
Yes, sir. Yes, sir.
Yes, sir. Yes, sir.
Hello.
Yes, yes, sir. Yes, sir. You are audible. Please go ahead.
Yes. Doctrinal research in particular is the bedrock of legal inquiry. It involves deep analysis of statute, case laws, judicial decision, and legal principles to extract meaning, resolve inconsistency, and build legal argument. We are honored to have with us today Professor Dr. Azim Khan Pathan, who currently serves as Dean and Professor, Faculty of Law, Kalinag University, Naya Raipur, Chhattisgarh. His biodata is of 25 page, but due to the short of time, I am reading crucial points of his academic journey. So Professor Pathan has 19 years of academic and professional experience. Before joining Kalinag University, he has held faculty and administrative roles at several reputed institutions such as GD Goenka University as a dean and professor, Galgotias University as in charge dean and professor, head Center for Studies, UPES, Dehradun, associate professor and head of department, and Hidayatullah National Law University, Raipur, faculty and research associate. He also practiced law at the District Court Yavatmal and Bombay High Court Nagpur bench. His doctoral research was on climate change law with major academic environmental and comparative public law. He has published articles widely in reputed journals and edited volumes, including works on contempt of court procedure, narcotic and psychotropic substances, euthanasia in comparative perspective, and legislative process during COVID-19. He has also been reviewer for internationally reputed journals and guided research at advanced level. Professor Pathan has led a research project on ethanol energy adaptation, livelihood challenges of farmers, and cybercrime. Beside contributing as an academic leader in curriculum and policy development. It's my pleasure to make you acquainted with the fact that Azim sir is alumnus of our college at Yavatmal. Sir, with such a multifaceted experience in legal practice, academia, and administration, especially in top law schools, we are privileged to have you as our resource person. Your guidance on research method and doctrinal approaches will greatly enrich our understanding and sharpen our abilities in legal research. With this word, I welcome all our participants and guests again. And now I invite Professor Dr. Azim Khan Pathan to take over the session and lead us into a deeper exploration of research method and doctrinal research. Thank you, sir. Over to you.
Thank you very much, Professor Dr. Budot. And thank you very much for inviting me for this very important faculty development program, which is ongoing in Swatantya Senani, Dr. Swatantya Senani Jawaharlal Dardaji on the campus of College of Law. And indeed, it is my great pleasure to get connected you know, the soil, my alma mater, and I considered this is great opportunity indeed, you know, to talk or indeed try to, give certain important nuances in this field of law, especially from the prism of research and research method, and then more specifically with reference to doctrinal research, how contemporarily it is currently ongoing, and it has to be, taken care, and it has to be explored by all, the research scholars, including, me, including everyone, how we have to, take ahead a legal scholarship. So in that context, I find this great opportunity, and I extend my heartfelt greetings as well to the entire management and entire, the School of Law, Jawaharlal Dadaji School of Law. Um, and indeed, today we will be talking in the context of this very crucial, important, the topic. But before that, let me also, extend my heartfelt gratitude to Professor Nagrale and all faculty members of College of Law, Swatantya Senani, Jawaharlal Dada College of Law, and all participants indeed who have, gathered, who have participated in this very important faculty development program. Let me share my, screen before going in our further discussion. Hope I'm audible there.
Yes, sir.
All right. My screen is visible.
Yes, sir.
Fine. Now slideshow is visible. Kindly
Yes,
confirm.
sir.
Yes, yes,
Yes,
sir.
sir. Yes, sir.
Great. All right. So fine. So chat box is also open. Indeed. Meanwhile, we will set the tone of first of all our this entire discussion. Let me also give you certain important input. Let it be more interactive. If you cannot hold the question, please keep it in the chat box so that we can go further with reference to those important your queries, questions in between the discussion. Apart from that, if you can hold at the end of this session your certain questions, that is also better. But if you cannot hold, then you can also write in the chat box so that I can take up in the ongoing discussion our these all important questions or queries as well. But let us go ahead now with reference to our very important discussion points which we are going to explore today in the backdrop of doctrinal research, and more specifically the interdisciplinary approach as well, how exactly it is being referred through doctrinal approach. But before that, and especially this particular doctrinal research, we will be exploring with the help of a current contemporary dialogue and discussions, and how exactly it is reflecting through the judicial pronouncements as well, the constitutional jurisprudence, how it is also most of the time based on a doctrinal research method or doctrinal research method, including the interdisciplinary approach. So in that context we will have this important the discussions. But before that, I just want to understand from these all participants, very important the discussion point. We are talking in the context of research method, and then more specifically the doctrinal research. But before that, I just want to understand from all participants, is there any difference in between research method? I'm repeating my question. Is there any difference in between research method and research methodology? I'm just putting this question, why? Because to set the tone of this entire our discussion, you can even write in the chat box. You can even open your mic, and you can answer this particular question. Let us have a more two-way track discussion, so that we can have a lot of certain outcome out of this particular subject, out of this particular FDP session as well. What is exactly your idea? Is there any difference in between research method and then more specifically research methodology? You must be hearing this particular the two different important terms continuously in your different sessions of this faculty development program. So I'm just putting this question from any participant. Hope I'm audible there. All right. Let me go ahead. Let me tell you the very basic idea in the context of, research method and research methodology. When we are talking in the context of research method, these are nothing but the ways, simple ways, where how exactly and in what way exactly we are going to collect the data, or what kind of data we are going to collect related to our, research problem. Research method, you can also say that it is systematic ways to, apply certain important tools, techniques as well. Not only doctrinal research is one of the important method, or non-doctrinal, nothing but empirical research is one of the method, but there are other different important, methods as well. Participatory research, non-participatory research, apart from that, we are also saying that there are, other important, methods, including, socio-legal research method as well, interdisciplinary research method as well. So these are the certain important, we can say, the directions. You have to first of all understand what is exactly nature of the problem, and then you have to, apply a different method. Doctrinal research method is also one of the important, we can say, the systematic ways, or systematic, we can say, systematic, we can say, the ways or systematic, types of research which is being applied for, we can say, collection of data, or, exploration of relevant data. But what is that we will explore step by step. But for that, for application of any method, including doctrinal research or empirical research, we have to have, a thorough understanding of nature of the problem which we are going to take in our hand. Because you will be exploring, statement of problem, or problem of the statement of your study. At that particular time, you have to understand, very systematically, when you are reviewing your literature, what is the nature of this problem, whether I will be able to justify this particular, the problems finding only basing my research, including doctrinal approach or doctrinal method only, or should I also go for, non-doctrinal approach. So for application of, method or different types of your research, you have to first of all understand, what is the exactly the nature of that problem. Let me give you the example. If we are, going to talk about that many, daily wages, laborers who are, working, around you or around me, all over the, the society, we are continuously, observing most of the time in unorganized sector as well, or even organized sector as well, even, in the different factories, the minimum wages, this particular act we have brought, no doubt. But most of the time we are also seeing in unorganized sector, including organized sector as well, that the one particular, the laborer who is getting very minimal, the wages. So this is the important, issue. If you are going to explore through your research, now you have to understand what exactly is the problem or nature of problem, based on your review of proper systematic review of your research. Because this particular problem, with reference to minimum wages of unorganized sector people who are working around you, in your that particular geography, you will not be able to justify, or you will not be able to, come up with a foolproof solution or foolproof suggestions to the policy maker, unless and until you are not basing your research based on non-doctrinal approach. That is nothing but empirical research. Because here, doctrinal approach or doctrinal research will not go, or will not, solve the purpose of this particular, issue. So because of that, you have to understand, first of all, the nature of the problem before application of any method or research method. So that is very important, because here, with reference to, people's issue, minimum wages issue, unless and until you will not go and understand the experiences of those, unorganized sector people or those laborers, through your empirical research, through your, different tools and techniques, including, your questionnaire method, or including your observation method or interview schedule, you will not be able to, bring for analysis a real-time data or real-time experiences of those specific, respondent or specific target group. If you will be relying, predominantly with reference to this unorganized sectors people or those daily wages people's, wages issue, if you will not explore with the help of non-doctrinal research, you will not be able to justify, or you will not be able to provide a foolproof solution, or at least, approximate solutions for that particular, issue. So with reference to nature of the problem as well, you have to choose a research method. If you have to clarify a certain, interpretation, textual interpretation of certain issue, just like, daily Supreme Court of India, they generally do. I will tell you that Supreme Court of India, daily they do, a doctrinal research. Or along with them, both the parties litigants as well, or most of the time, Union of India and other, the private people or private parties, they generally do, or their advocate generally they do, a doctrinal research. Because most of the time there is requirement of, a textual interpretation or earlier explored doctrines to bring out a new, or bring out a interpretation. So in that context, or certain, issues, it can be solved, or it can be, properly analyzed purely based on, doctrinal approach, purely based on commentaries, purely based on, textual, interpretation, or purely based on, we can say, a statutory provisions or appellate courts, decisions or pronouncements. So when we are talking about research method, these are the different, we can say, the ways which we can apply to solve a different research problem having different natures. So you can apply sometime doctrinal research method for solving your problem of the study, or you can apply sometime non-doctrinal research or non-doctrinal approach for solving the problem. In doctrinal approach, predominantly recent trend is there that interdisciplinary approach or even interdisciplinary research, we can say, it is also being read out. It is also being, read out, from the side of legal scholarship. So in that context, I was, starting this discussion point that what is exactly now, the very basic difference in between research method one side and then research methodology other side. Now, research methodology, when we are saying, there is, very thin line, but we cannot say thin line difference is there, but very carefully you have to, see these both, terminology. When we are saying research method or different research methods, we are saying with reference to certain ways which we will be applying in our research for solving any particular, the problem. We are going to, apply certain, a nature of method for solving our problem. It may be doctrinal research method, it may be non-doctrinal research method, it may be empirical research based on, your questionnaire method as a tools and techniques for collection of data. So methods are nothing but the ways for collection of data. It may be, commentary you may be collecting with reference to doctrinal research approach, or it may be, the certain questionnaire or certain responses you may be collecting from the field, of those daily wages people, with reference to empirical research. So these are the, we can say the methods of research. But how and why you are using, just try to remember this particular, statement which I am, quoting here, that research methodology is something different. Research methodology and the difference in between research method, you have to understand. When we are saying research methodology, it is, complete design of, your research, that research problem, why you are using. This is nothing but the answer. Research methodology is nothing but, that is methodology. Something logic is there involved in that term itself, which says that research methodology, it is based on logic. And what does it mean? It means that why you are using a particular method. If you are using, a doctrinal research for solving your problem of your, the study, why you are using that doctrinal research, and whether really this doctrinal research is going to provide a probable solutions to your statement of problem, it is nothing but the justification. Why exactly you are using an empirical research method looking to the nature of that particular problem? So that is nothing but your research methodology. So this is basic, difference in between research method one side and then other side research methodology. When we are saying research methodology, those are nothing but purely a different methods. But when you will be saying in your, entire introduction of your study, including, entire your research design, right from, statement of problem to rationale of the study to exploration of research questions to, use of any particular research methods, at that particular time you will be giving the explanation, justification, why exactly you are using a doctrinal research, why not you are using a non-doctrinal research. And if you are, using with reference to minimum wages people's issue, if you are exploring with reference to, empirical research, you are telling there that why empirical research you are, using as a research method. Why you are using? Because you cannot, study this particular nature of the problem unless and until you will not go on the field and collecting the real experiences of those respondents. So that is the basic difference. I have used here research method and research methodology before going in our, the discussion point. So now question comes. Hope I am audible there.
Yes, sir.
Yes.
Yes, please keep dropping, your questions as well in the chat box. If you cannot hold, your questions, I'll be taking up, those questions from those chat box. So now going ahead with reference to our important discussion point. Now, this particular discussion point in the context of, doctrinal research and interdisciplinary research will be exploring in the context of current contemporary dialogue and discussions from, the Supreme Court judicial pronouncements, and where you will be, understanding in actuality how doctrinal research predominantly most of the time can help or can bring, lot of clarity in the legal scholarship. And you know that when we are talking in the context of, the dynamics and significance of doctrinal and interdisciplinary research, doctrinal research and interdisciplinary research, continuously Supreme Court, in our country is taking into consideration this doctrinal approach predominantly, including interdisciplinary approach. But what is this doctrinal research? I will not be, more theoretical. I'll be more, in actuality, what is happening and how exactly you can explore, a doctrinal research method in your research work, giving the justification in your entire research methodology why you are using a doctrinal approach or interdisciplinary approach. So for that, you have to understand, certain important legal propositions, certain important, the background and backdrop of this doctrinal research. So in a simple way, when we are saying that doctrinal research is based on legal propositions, that is nothing but legal doctrinal research or doctrinal legal research, because predominantly our research is based on a legal literature or literature which is more associated with law or legal we can say the doctrines. So doctrinal research we are saying, or doctrinal legal research we are saying, it is based on legal propositions by analyzing the existing statutory provisions and cases by applying the reasoning power. So see here, three different important, the variables are very important to understand the significance of doctrinal research. One side, doctrinal research is based on, legal propositions. Where we can find these legal propositions? Most of the time we can find these legal propositions, by way of judicial precedents, by way of, statutory provisions, by way of, different rules, by way of even the different law commissions, the reports, by way of, different propositions which are, explored in those documents, those authoritative documents. And then, we are also saying the legal research is also based on, analyzing the existing statutory provisions. So doctrinal research is also based on, not only the legal propositions, but at the same time statutory provisions and applying the reasoning power. Now, let me give you the real time, the examples with reference to this doctrinal legal research method, how it happens. We are seeing, currently, recently as well, in the context of especially this your Fahima Shirin versus State of Kerala case. This is the case of 2019, which was explored from the side of single judge bench of High Court of Kerala. Now, if you will see carefully, this particular, the final judgment which was written from the side of, Justice Asha as a single judge bench with reference to the, the petition under Article 226, which was, and 227, which was, filed from the side of Fahima Shirin, the student of BA degree. When this particular, the issue, it had come with reference to, there was stoppage of mobile phone use, and there was, prevention of, more specifically with reference to use of laptop inside the hostel or that, college hostel. Then there was the stoppage of this access to internet, and then, mobile phone use during evening hours, right from 6 o'clock in evening to 10 o'clock. There was totally restriction on the use of mobile phone and internet access inside the hostel in the state of Kerala. In one particular, the college and hostel administration, they had issued that particular, circular. So becoming aggrieved by this particular, the stance or this particular, the decision of hostel administration, this Fahima Shirin and her other, hostel inmates, indeed, Miss Ritu, who are also, the BA graduation, who are having their admission in BA graduate, undergraduate degree. So they indeed approach before the hostel administration, and then they asked that this particular kind of, the order of hostel administration is totally, against their education, educational right, right to education, right to life, right to have dignified life, freedom of expression as well. And it is exactly, the arbitrary order, because most of the time they are, dependent on, all swam courses, MOOC courses, and online courses as well. If they are not having access to internet or their mobile phone, then they will be deprived of, getting education one side. They will be deprived on other side, from more their information and more knowledge base as well. So that was the some or the other way certain important, contention in the representation made from the side of Fahima Shri. But this particular, the request and appeal, hostel administration, they had totally, rejected. So there was no other option, for the Fahima Shirin, and then more specifically her other hostel inmates as well. They approached before High Court of Kerala, filing this, petition under Article 226 and 227 of Indian Constitution for, how exactly this particular, hostel administration order is against their fundamental rights, against their, rights, constitutional rights. So in that background, Justice Asha indeed, brought this something new, approach. And that approach, if you will see, and if you will try to explore carefully, all participants here, all researcher here, all every, learner, including me, if you will try to explore that analysis, this analysis is purely based on, doctrinal research, because this analysis was purely based on different legal propositions. This analysis or final judgment, which I am going to quote here as well, it was based on analysis of existing statutory provisions. This case, which was, also, applying different cases. This Fahima Shirin versus State of Kerala 2019 case, it was applying a different cases. And it was also applying a reasoning, deductive reasoning, not only the inductive reasoning, deductive reasoning as well, from general to particular. So here you will find this is the purely a case or final order. It is based on, a doctrinal approach. But how it is doctrinal approach, that we have to understand. So I am making this, clarity for the sake of all participants. In this particular judicial pronouncement, there were different legal propositions were taken into consideration. One side, there were different, constitutional provisions taken into considerations. Different, statutory provisions were taken into considerations. Different, reasoning that was also taken into considerations. So purely, if you will see carefully, this was the research. The judgment is the output of or outcome of, entirely the application of doctrinal research. But now we will go in that particular judgment inside as well. Because in front of you on my slide, even if there is only one statement written, but based on this one statement which is saying that legal proposition and analysis of existing statutory provisions, and then by applying the reasoning power, how it happens in actuality. If you will see the Justice Asha's work, in this Fahima Shirin, she has taken into consideration the existing legal provisions and existing legal propositions as well. She has, stated that, this particular, the hostel administration's order, it is in actuality is not facilitating the right to education. When, entire SWAM courses, MOOC courses by university grant commissions, which has been, facilitated in this digital India model, then that particular, the students are not close to that particular literature just because of, access to internet, or just because of, restrictions of use of mobile phone. If it is happening in the hostel or hostel administration. So that some or the other way it is, breaking off, or it is some or the other way, stopping off, facilitation of that particular right to education one side and right to information other side, and that right to education guaranteed under Article 21 capital A on other front as well. So see how beautifully, Justice Asha has taken one side those legal propositions, existing statutory provisions, existing, constitutional provisions, and on the top of that, she has also referred one new approach as well, purely doctrinal approach. She has also referred that why international legal propositions which are coming through, different resolutions, which are coming through different, declarations, which are coming through different, protocols, which are coming through different conventions, that should not also be interpreted in the context of giving a way to the constitutional rights and fundamental rights. Because that particular version or that particular legal propositions already, long back in Francis Corley case, or already long back with reference to Indian Council for Enviro Legal Action case, or with reference to, more specifically Vishakha's guideline case, or with reference to other important judicial pronouncements, the Supreme Court of India had already made that particular legal propositions that when there is no contrary, in between international law, contrary in between international law and domestic law, then whatever, international declarations, international protocols, conventions that can also be interpreted to solve the existing problems of the society, through the judicial creativity or through the making the different legislations as well. So these particular questions, that legal proposition Justice Asha has also used, taking into consideration that MC Mehta case, Indian Council for Enviro Legal Action case, where Supreme Court had asked a specific question that why not, this polluter pays principle or precautionary principle, the existing legal system should use, for making a more clarity and giving a way to pollution free and healthy environment within the purview or within the four corner of right to life and personal liberty, or right to life as a facilitative of pollution free and healthy environment. Why not the obligations on the part of, all factories, industries as a precautionary principle or as a polluter pays principle, why it should not be implemented against the polluting industries in the context of pollution free and healthy environment should become one of the important facets of right to life. So see, Fahima Shirin versus State of Kerala, this particular judicial pronouncement, how it was, bringing purely that doctrinal approach, purely how legal propositions, purely those statutory provisions, purely those international conventions, and that particular discourse, Justice Asha, she was using while writing that final, the order of final judgment in this Fahima Shirin case. So when we are saying with reference to this very first line that the doctrinal research or doctrinal legal research is based on legal propositions by analyzing the existing statutory provisions and cases, applying the reasoning power, you have to understand that one side in this Fahima Shirin, there are different legal provisions were taken into consideration. Legal, the statutory provisions were taken into consideration. Different legal propositions were taken into consideration, different international legal instruments. Now here, which important international legal instrument that was referred from the side of, Justice Asha, that is also very interesting to look into, because this particular approach of Justice Asha at later stage, the Supreme Court of India in Anuradha Bhasin, immediately after 1 year, that is 2020, because this case of Fahima Shirin, it was the case of 2019. And Justice Asha had given this particular, the final, disposal to this case, Fahima Shirin, in 2019 only. But in 2020, the Supreme Court of India in the case of Anuradha Bhasin versus Union of India, the approach which has taken, the interpretation which was made, or the doctrinal approach which was used for, bringing an interpretation of Article 19 and Article 21, that was that particular approach, or that particular, doctrinal approach of Justice Asha, that was not taken directly into consideration from the side of, Supreme Court of India in Anuradha Bhasin. Because here, in this Fahima Shirin versus state of Kerala, Justice Asha, she read out that access to internet as an independent right to freedom of speech and expression. She interpreted independently access to internet as a matter of right. That was the final interpretation, and based on that, she had also given the final order and given the order to the hostel administration that in the because it is violating, your order is violating Article 19, Article 21, because access to internet is one of the important facets and rights of freedom of speech and expression. She made that particular legal proposition in this judgment. But that approach, indeed, see, it is very interesting when you are, applying a doctrinal research and exploring some important issues with reference to constitutional jurisprudence or with reference to any other field as well. You have to understand here, the nitty-gritty, how you can play, or most of the time how, the Supreme Court also play, or different high courts also play with this doctrinal approach. But in 2020, in the backdrop of abrogation of Article 370, when this case was in front of the then Chief Justice, Justice Deepak Mishra were there on the bench. Then Justice Chandrachud, he was also in the bench. Justice Khanvilkar, he was also on that particular bench in the case of Anuradha Bhasin versus Union of India. But in this case, 2020, the Supreme Court has not taken that approach. That particular, the legal propositions, or that doctrinal approach, analyzing the same, the legal approach or same interpretation based on the reasoning power, Supreme Court made it, totally different. They did not read out, they did not read out, indeed, international legal instruments, that doctrine, when there is absence of any particular, application of international legal instrument. They have not, indeed read that particular approach while bringing, the final judgment in Anuradha Bhasin case, in the backdrop of abrogation of 370, and in the backdrop of that, the journalist Anuradha Bhasin, the Times, the journalist, the Time magazine journalist, she had claimed that there is clear-cut violation because of suspension of internet in that Jammu Kashmir area, and because of, their, this journalism, online journalism, it is at stake. So there is clear-cut violation of one side, freedom of speech and expression guaranteed under Article 19, Clause 1, Subclause A, and other side, she had also claimed in 2020 before the petition, while filing the petition before the Supreme Court of India, there is clear-cut, violation of not only Article 19, Clause 1, Subclause A, but at the same time, there is also violation of Article 19, Clause 1, Subclause G, with reference to freedom of occupation, trade, and business as well. And consequently, there is also violation of, reasonable restrictions. It is not based on the ground which is prescribed, in Article 19 clause 2 and Article 19 clause 6, respectively, with reference to Article 19 clause 1 subclause A and Article 19 clause 1 subclause G, with reference to one side freedom of speech and expression, and then other side with reference to freedom of trade, occupation, and business. So in that backdrop, the Supreme Court, Justice Deepak Mishra, Justice Khanvilkar, Justice, the Chandrachud, they interpreted not that approach of, Fahima Shirin or one judge, single judge bench. I'm not saying that the single judge bench, the judgment, it is, mandatory, or it is, we can say authoritative precedent for the Supreme Court, but that approach was not exactly interpreted. But totally different approach, the Supreme Court of India has taken into consideration while interpreting, this particular fundamental right with reference to Article 19 clause 1 subclause A and Article 19 clause 1 subclause G. But Faima Shirin, what was that other approach? Because Faima Shirin, Justice Asha, she had also taken the help of international legal instrument like United Nations Organization. That legal proposition she had taken into consideration while saying that access to internet is also one of the important facets and right, grounded in Article 19 clause 1 subclause A and grounded, in more specifically in right to education guaranteed in Article 21 capital A. She referred that United Nations Organization's resolution which UNO had passed on 1st July 2016, where United Nations Organization, indeed had brought this particular, the resolution, where all along, different country parties of UNO were the signatory of that particular resolution. Even if that was non-legally binding resolution, but it has also certain important, the impact on the evolution of jurisprudence all over the world. Because this resolution had stated that whatever is, available, offline, it should also be available online as a matter of human right. So access to internet, it was considered by this resolution as a facets of, as an integral part of human right. So UDHR, if you will see carefully, Universal Declaration on Human Right, 1948, because your work through doctrinal research is nothing but finding out those important legal propositions from different resources, different doctrinal resources, different, the commentaries, different, documents, because doctrinal approach is predominantly, dealing with the documents one side, dealing with the doctrines other side, dealing with the, the juristic opinion other side, dealing with the, different commissions report other sides. Means you are dealing with the documents. It may be international documents, it may be national documents, it may be any comparative, the documents as well, or comparative study as well. So here, the Justice Asha, she was referring Universal Declaration on Human Right, Article 1 of Universal Declaration on Human Right, which says that this is also human right of freedom of, the free speech and expression. It should be facilitated by the state. This is the responsibility of the state to facilitation of those, freedom of speech and expression by any means and any mode. That is specifically, written in that legal propositions. The very first bullet point of our this discussion point on this slide is that, doctrinal research is predominantly, playing with those different legal propositions. So Justice Asha indeed was referring that UDHR, very first article, which says that freedom of speech and expression, that should be facilitated by any state, by any means and any mode, by any media, any medium. So automatically it is inclusive of even the cyberspace, even this whatever internet or whatever, the World Wide Web or whatever, these online resources, digital resources, whatever we are seeing. So that freedom of speech and expression, right to know, right to information, as far as concerning to domestic legal system, it can be interpreted in our existing constitutional jurisprudence, and that the same thing, Justice Asha, she has interpreted, but she has interpreted in the backdrop of, try to remember here carefully, through your doctrinal research approach, she has used in the backdrop of, the legal precedents which has already come in 1996. One side Francis Corole case, other side Indian Council for Enviro Legal Action case, other side in 1997, Vishakha's case as well. The approach of Supreme Court was there when there is absence of, or vacuum in our legal system, or there is no any specific, statutory provisions to solve the problems, then the reference can be made to the international documents or UDHR or our covenant, civil political rights covenant, or other declarations, covenant, conventions, international legal instruments, and that has to be interpreted as well. That approach of Indian Council for Enviro-Legal Action case, that was taken into consideration by Justice Asha with reference to this Faima Shirin case. To disposing this particular case, they have taken that approach. And indeed, UDHR's very first article that was read out to bring out more clarity that whether access to internet or use of mobile phone digital database is also integral part, or is also integral part of Article 19 or right to education or not, whether it is there, the part of that or not. So that, for making clarity in that particular the issue, this doctrinal approach, indeed it was used from the side of Justice Asha. So see, you will find that even if one line is written here in front of you with reference to this particular presentation, which says that legal propositions by analyzing existing statutory provisions and cases by applying the reasoning power, you will find that it has tremendous jurisprudence involved in that, in practicality, in actuality. Similarly, you will find when I am saying that, how exactly new interpretation it has come after 2019 in the backdrop of your 2020 case, this Anuradha Bhasin versus Union of India case. This is also purely the case or judicial pronouncement based on a doctrinal approach. Faima Shirin, it was not only based on doctrinal approach, but interdisciplinary approach was also used there. Interdisciplinary research was also used there, because Justice Asha, she interpreted that now in this new age, in this digital era, most of the fundamental right, constitutional rights, it cannot be, or it cannot stay in loof, or it cannot stay away from the influence of technology, because ultimately technology is facilitating many many fundamental rights, including dignified life, including right to education. So technology is one of the important facets of dignified life, right to information. So she brought that that social science approach as well, that how society is growing. So that interdisciplinary approach, not only the law, not only the legal documents, but how technology is growing, how exactly society is growing, that new approach as well, along with this doctrinal research method, where there is only limited use of doctrines, legal propositions, statutory provisions, but along with that approach, interdisciplinary approach as well, Justice Asha, she used while bringing out the final judgment in Faima Shirin case. But next, when we see this, the 2020 case, Anuradha Bhasin case, the case is very simple. Everyone must be knowing, because this is the age of, the fast, real time, we can say the information is flowing from one part of the world to other part of the world. So you must be knowing this particular, the backdrop Anuradha Bhasin. When in the backdrop of, is 2000, constitutional, 2019 constitutional amendment, and then abrogation of this Article 370, when it had happened, to some or the other way, to regulate this public safety, with reference to national security, based on those important parameters, based on those important, we can say, the restrictions, there was suspension of internet services in territory of Jammu and Kashmir. This is very interesting, example of doctrinal research. And you will find, more, we can say, the interest to explore, further as well. Because when this particular thing happened, this Anuradha Bhasin, who was the journalist of this the magazine Times, the times, she directly approached before the Supreme Court with the petition, saying that there is clear-cut violation of, and this is, arbitrary action, because in continuation, there is stoppage or breakdown of, this internet in the entire territory of Jammu and Kashmir. So this is one side, arbitrary. It is one side. Other side, it is, totally violative of Article 14, violative of Article 19, violative of, freedom of speech and expression, including freedom of press, which is read out right from Ramesh Thapar case in 1951, 1954, Ramesh Thapar case to, your Bennett Coleman case, that freedom of press is also integral part of the freedom of speech and expression. So she claimed, she contended before the Supreme Court, saying that this is also not only violating of Article 14 and Article 19, it is also violating, Article 21 as well. But here you will find that the Supreme Court, heard both the sides. One side, the petitioner, other side, government side as well. And Supreme Court has also evolved something new interpretation, new solutions to this problem. The contention was there that whether this particular, the suspension order of this internet, is it violative of Article 19, violative of Article 14, or violative of Article 21 or not? That was the major predominant question before the Supreme Court. So see, in your research as well, you may be having like this issue, and how exactly you can think, the way forward. Even today we are having, in 2025, you can even bring a new solution based on till yesterday's all legal propositions. You can think differently. You can interpret those legal propositions, you can interpret those doctrines, and you can bring out the new interpretation which will be helpful for the Supreme Court for tomorrow, or Supreme Court for, after 1 year, or Supreme Court for, after 3 years. Your research, which is based on doctrinal approach, it is not exactly, giving something new solutions to solve the problems of the society, but it will also solve, with the help of doctrinal research, the problems which we will be facing in coming time as well. So Anuradha Bhasin, this particular, case, indeed in actuality and in reality, brought very interesting questions before the entire country. And see, Supreme Court, one side, Supreme Court of India, one side, used the existing legal proposition, used the existing doctrines, existing, we can say the statutory provisions, constitutional provisions, and they have also used on the other side reasoning as well. Reasoning, I am using more specifically reasoning. They have used the inductive reasoning as well from specific instance to develop a general principle. Inductive reasoning. This is very powerful tool of your doctrinal research. Now, how exactly it happens, and how exactly, Supreme Court, use this particular doctrinal approach, you will surprise to know. Because if you have, a systematic scientific, study through this, research method, daily you can also start, writing a new interpretation for Supreme Court of India. See, in Anuradha Bhasin, indeed, Supreme Court was dealing, earlier judicial precedent. When question was there whether really, stoppage of access to internet for unreasonable time or extended time, is it violative of Article 19, that is freedom of speech and expression, guaranteed in Article 19, Clause 1, Subclause A, and then freedom of trade and occupation, guaranteed in Article 19, Clause 1, Subclause G, whether it is violative of these fundamental rights or not. That was the major predominant issue. So Anuradha Bhasin, she claimed that this particular, the order or different in different regions, different, the territory, different collectors, they have not indeed published those particular order for the suspension of internet services in those particular territory. Some orders are in continuation, since last, 1 year as well. And it is directly affecting our, online journalism as well, our trade as well, our occupation as well. This is a clear cut, violation. It is not even based on those grounds which are, prescribed in Article 19 Clause 2 and Article 19 Clause 6, respectively, with reference to freedom of speech and expression, reasonable restriction, and respectively with reference to freedom of trade, occupation, and business in the context of Article 19 Clause 2. So see, for giving the answer to these particular questions in front of Supreme Court, in front of the judges, including Justice Khanvilkar, Justice Chandrachud, and Justice Deepak Mishra, they were having different legal propositions in front of them, which was in the context of even, Fahima Shirin in front of them, even Shreya Singhal was there, that judicial precedent in front of them, even, they were having, other important judicial precedent in front of them, including, Swapnil Tripathi versus Supreme Court of India case as well. They were, dealing with those all, different judicial precedents as a legal propositions, including, the constitutional provisions. So here you will find that the first time, not exactly first time, but more clarity that has brought from the side of Supreme Court in earlier doctrines with reference to doctrine, with reference to doctrine of proportionality. What is the doctrine of proportionality which has evolved in your, more specifically in the backdrop of, your earlier cases like Kisham Meghchandra Singh versus, Kisham Meghchandra Singh. This is the case of 2020 itself. Then apart from that, if you will see carefully other important judicial pronouncements as well, so you will find that, the Supreme Court of India itself, earlier they have brought, they have evolved the doctrine of proportionality, but more clarity that has been brought by way of Anuradha Bhasin while interpreting this, this particular issue which had come before the Supreme Court by way of this Anuradha Bhasin. So Supreme Court said that this whatever restrictions that has been, brought on the freedom of speech and expression in the backdrop of Article 370 by way of, the orders of different collectors and different commissioners in that particular region for suspension of internet services in that particular region. No doubt those are based on, certain reasonable restrictions grounds which are provided in Article 19 Clause 2, which says that with reference to, security of the national security, and then with reference to public policy, national security. So those ground, based on those grounds, some restrictions it can be, brought based on your freedom of speech and expression. No doubt. They agreed that particular point. But Supreme Court further, with the help of these legal propositions, and then, extracting, through legal reasoning, some new interpretation, they solved this problem and they stated that this particular, the restrictions which are imposed based on the grounds which are given, in Article 19 Clause 2 and Article 19 Clause 6, those should also be based on reasonable connection. Those should be based on intelligible, the connection as well. Those should be based on necessity as well. It should be based on proportionality. In simple way, what exactly, the Supreme Court wanted to convey by way of this necessity, by way of this proportionality. Just I am giving the example. I am giving you here the example. If, in earthquake, 10 buildings of Yavatmal, if, say for example, for God's sake, 10 buildings, of Yavatmal, those are in a dilapidated situation. 10 buildings, say for example, in a situation of, in any time, it may collapse. It may collapse. But there is also yet another building adjacent to those 10 building. It is perfectly fine. Just 20 feet away from this 10 building, in the backdrop of earthquake. But now, this municipal council of Yavatmal, they pass, or they brought the order or circular that anytime this particular building, all building may collapse. So you just, go there and, you just abolish, and these all buildings should be, made clear from there, from that particular, place, because this building anytime it may collapse. So you clear those buildings, you demolish those all buildings, including that building number 11. So now question comes here, and the Supreme Court indeed wanted to convey that particular aspect of proportionality. So see, these are nothing but based on that reasoning, based on that, logic, based on that, fairness that was being interpreted. That Supreme Court was saying that if this particular, restriction on freedom of speech and expression and freedom of occupation, it is one of the important, the object or necessity, then it should be based on more proportionality. It should not have been, extended for in continuation, for 1 year. If you feel that, and there should not have been, the blanket order for entire state. If you find that there is the threat to the national security in particular area, then only that particular district, identifying that particular, the place or district, there should have been, the suspension of the internet services. Means this particular complete blanket order, it is not based on the proportionality. So the similar example I was giving you with reference to Yavatmal district, those 11 buildings in the backdrop of, the earthquake, where your municipal council has passed the order to demolish those all 11 buildings. But it is not necessary, it is not proportional that building number 11th, it should have been also demolished in the backdrop of, this particular earthquake which had occurred. So there should be a proper specification which should be based on proportionality. That was the important, the message, or that was the important reasoning, or that was the important, the logic. The Supreme Court was interpreting the existing doctrinal research or existing legal proposition by way of Anuradha Bhasin versus Union of India case. So see how exactly it is interesting. You can come up with, the new interpretation with the help of doctrinal research, using the reasoning as well, just like, Supreme Court was using in 2020 the reasoning for solving the problem. So many problems, or many governance related problems, it can also be solved based on doctrinal approach. Let me give you here the example, very important example and very contemporary example. And I'm sure you will be connecting with this particular, the example which is purely based on doctrinal approach, purely using the doctrinal method in your, research, or purely, the Supreme Court of India has, used this particular, the doctrinal research in their new interpretation. We have seen, and everyone knows, that the right to privacy has come, in the backdrop of, MP Sharma case, your Kharak Singh case, when it was, overruled, no doubt, by way of this case Putta Swami, these all cases, because, small judge bench were there sitting in last MP Sharma case to give the clarity to these cases. Case Putta Swami has given new version that right to privacy is also one of the important facets of right to life. But see, from where exactly it has come, you should be wondering. Everyone is saying that that right to privacy in Supreme Court has used in 2017. But if you'll go in actuality, in the root cause, you will find that purely, there was a very, very systematic, interpretation of different judicial precedents, one side. Right from Kharak Singh to, your MP Sharma case, to, even, in the backdrop of your Menka Gandhi case, to, many other landmark judgments which were referred in this particular case. But apart from that, there were also the use of, the international legal instruments. If you will see the article 10 of Universal Declaration on Human Rights, or more specifically article 14 of Universal Declaration on Human Rights, you will come to know that international documents were already recognizing this privacy right as one of the important facets of human right. But we had taken almost, the more than 50 years to recognize this particular, the interpretation or particular right, we recognize in 2017. It was not like that this particular, rights were not in existence in other comparative jurisdiction or other, the parallelly other jurisdiction of this world. So what exactly Supreme Court in case Puttaswamy, Justice K.S. Puttaswamy 2017, in this particular case, in the backdrop of Aadhaar or validity of Aadhaar, and then that statute of 2016 and that pilot project of 2019 of earlier successive government, in that backdrop of that, when the Justice K.S. Puttaswamy approach saying that there is clear-cut violation under our fundamental right, that privacy right, our these all important personal information should not be asked, should not be regulated, should not be taken, and if it is being taken in the larger public interest, then there must be certain important, the reasonable, grounds as well. So that reasonableness, that proportional ground, proportionality, that test was also there, interpreted as well. But here you will find, very interesting, important point of discussion with reference to clearly interpretation of existing legal propositions, existing, statutory provisions, existing, we can say the different law commissions report or international legal instruments. Now, Universal Declaration on Human Rights, Article 10, Article 14, which says predominantly with reference to, privacy right as one of the important facets of human rights, that is one of the important responsibility of the state to implement, to, have that in their domestic jurisdiction. But that has not happened, since last 50, 60 years, but that had happened in 2017. So what made to the Supreme Court that to analyze with that reasoning power based on the available, the legal literature, to bring out that new interpretation? So ultimately, Supreme Court recognized that particular important point or evolving jurisprudence. So you have to also keep your eyes open that what exactly is evolving, how you can take the advantage of evolving the jurisprudence of the country for making out, based on, your reasoning power or clear-cut interpretation of existing legal propositions which are hidden in different judicial precedents, you can bring out something new solutions or new interpretation. Supreme Court brought that new interpretation by way of, this Anuradha Bhasin saying that UDHR is already recognizing, this privacy right. Not only they have referred the Menka Gandhi case, or not only they have referred, Francis Corley case, bank nationalization case, but at the same time they have also, interpreted the international documents, and with the reasoning that dignified life, or more specifically, the state control should not interfere in the inherent right of the citizens of the country, that new jurisprudence or we can say the old jurisprudence with reference to human rights, the Supreme Court indeed they have interpreted that, which was denied earlier before 2017. Whenever this privacy right, that was made the point or contention before the Supreme Court, that was earlier denied as a matter of right to life and personal liberty. But this time in 2017, what exactly it had made, because the entire world, you will find that you have to also understand the world trend as well, not only the the country's trend. If you will see carefully, the different jurisdiction all over the world, or the constitutional jurisprudence all over the world, the group rights now, or we can say those fourth generation right, earlier, or now, the new trends is coming, that individual right based jurisprudence is also evolving. Means there must be a minimal interference in the individual autonomy, that new jurisprudence all over the world as a matter of human right, which was already contended in Universal Declaration on Human Right, but it was totally away in many jurisdictions. But that was interpreted in this 21st century in 2017. It was not like the thing, this was not like the thing that it was not available. This jurisprudence was not available, individual right based jurisprudence. That right to life, right to personal liberty is also inclusive of right to privacy. This jurisprudence was already in existence, but with new reasoning, new trend, new development, that was interpreted, from the side of Supreme Court of India in 2020, more specifically 2017, by way of, your case, Puttaswamy case. And you will find there are new, ways as well. Now, for evolution of new doctrines, for evolution of new solutions, or new doctrinal, the problems as well. Let me tell you, in this particular, judicial pronouncement, Justice Kaul, 9 judges bench, the pronouncement, case Puttaswamy case, where Justice Kaul was also there, Justice Chandrachud, later he became Chief Justice of India, he was also there. There were all along 9 judges. So in one legal proposition in case Puttaswamy, the Supreme Court of India was saying very important one legal proposition. Hope I am audible there.
Yes.
Yes, yes, sir.
So Supreme Court indeed was saying and was making very important legal proposition. And Justice Chandrachud was making very important legal proposition. And that has made a tremendous impact for evolution of new interpretation at later stage after 2017. Had it been the part and parcel of that particular research, you would have come up with that new interpretation as well. But how it happens, how you have to, think, analyze those judicial precedent, reasoning power, statutory provisions, and it can bring something new solution. In that context, I am telling you, the Justice Chandrachud, he was saying there that right to life is also inclusive of right to privacy, and every individual, every human being, every citizen is also having, the autonomy as a matter of his personality, as a matter of his personal right, as a matter of his, privacy right. He has also, the right to hold his own personal information, right from, family to, personal information, mobile number, to any, biometrics, to any information related to his personality. Every individual is having the bodily autonomy. Every individual, see, these were different propositions. These were different propositions, legal propositions. Even if it was not, it was, say in the obiter dictum, not as a direct part and parcel of that, the authoritative, the precedent, obiter dictum, not as a ratio decidendi of this judgment, but those legal propositions, even if those were the obiter dictum from the side of, Justice Chandrachud, but it has made a tremendous impact in the context of, right to life, personal liberty and privacy right. That privacy right, this was also the logical reasoning there, or reasoning, that was used in this particular, judicial pronouncement, that privacy right cannot be exercised. That autonomy of the individual, if he is not having autonomy on his personality, on his information, on his biometric, then he is not in actuality exercising his, the right to life and personal liberty and privacy right. So he can deny as well for giving those, his personal information. So that was the, important, logical reasoning was being, carved out of this particular different legal propositions. From there, that 2017 interpretation of K.S. Puttaswamy, at later stage we have seen immediately, the new interpretation, it had come based on those, even obiter dictum as well of K.S. Puttaswamy case. We have seen the Navtej Singh Johar case. We have seen the Joseph Shaheen case in the backdrop of adultery. We have seen the Navtej Singh Johar case in the backdrop of LGBT people's right as well. So these particular cases were nothing but, in actuality, was nothing but the outcome of the earlier precedent, nothing but the precedent of K.S. Puttaswamy case. The world, or that particular Navtej Singh, Johar, or that particular case got the backup.
Sorry, Dr. Azim Khan, sir, to interrupt you in between. Though your lecture has been really intriguing and interesting to all of us. It was really great listening to you, sir. But since our program is a time constraint, there is time constraint. We have a time constraint, sir. So it's a gentle reminder from the side of Niger to kindly make it little shorter, sir. Since our
Thank you. I'll conclude quickly. Right. So what exactly I wanted to convey from here, that this particular judicial pronouncement, K.S. Puttaswamy, has made a tremendous impact for even doctrinal research approach. And then we can find that different interpretation, obiter dictum from the side of, K.S. Puttaswamy, which was made from Justice Chandrachud in this particular case, has tremendous impact in Navtej Singh Johar's interpretation as well. In Navtej Singh Johar's interpretation, when, this section 377 of Indian Penal Code, the then Indian Penal Code, now Bharatiya Nyaya Sanhita, when it was, said that is being, declared unconstitutional for LGBT people, more specifically, not for other unnatural, offenses. But in that backdrop, this bodily autonomy, that particular legal propositions, that was interpreted to its fullest extent based on reasoning power. So here, the takeaway ultimately from this session is that, already in, you are having availability of those all legal propositions with you, all international documents with you, all important international legal instruments with you, all important statutory provisions with you, all important, we can say law commissions, conventions, those are there with you. And it is also with the Supreme Court of India. It is also with the legal scholarship. But it is ultimately for you to bring out, new solutions by using that reasoning power. And by that, it is possibility that you can also come up with new interpretation for giving the solutions to the existing problems of the society. And that is nothing but ultimately the characteristics of doctrinal research. That is ultimately nothing but the doctrinal research approach in the legal domain. So with this, I think I will rest this discussion point. If there are certain queries, house is open.
So much, sir. Indeed, very insightful lecture. And we are deeply grateful to you, sir. And at the same time, we're so sorry that to make you white like that, sir. Our time constraint. Hope you will. And let us quickly take one or two queries from our participants, if there is any, quickly. Is there any? All right. Shall we assume that there is no query or any doubts from our All right. Then let's assume that there is no query from our participants. So once again, thank you so much, Professor Azim Khan, sir, for your very delightful speech. It was really insightful and intriguing at the same time. So with this, yeah, we will move forward to our next technical session because our second resource with us. So may
Very
I
good
take the
morning, Dr. Payal, madam. Very good morning.
Good morning, Azim. How are you?
I'm very fine. Thank you very much. Nice to see you on this,
Yes,
the screen.
yes, nice to see you. And sorry, I have to interrupt your lecture, but I
No, no,
have,
no, fine. I was, concluding. I was coming to the conclusion.
I understand. I understand. Yes.
So thank you very much, Dr. Azim sir, for
Thank you.
a
Thank
very
you.
insightful lecture.
Thank you very much. May I take leave? I wanted to, listen to Dr. Payal, madam, but I have certain 2, 3 works today. Uh, I
Next
will
time,
join.
next time.
As you wish, sir. Okay.
Thank you. Thank you so much. Thank you very much.
Okay.
all right. Okay. Okay, friends, let me quickly give a brief introduction of our resource person, namely Dr. Payal Thaorey. Dr. Payal Thaorey is presently working as a selection grade assistant professor at the postgraduate teaching department of law, RTM Nagpur University, Nagpur. Madam had been the head of department of the postgraduate teaching department of law, RTM, for almost 4 years during the period of February 2022 till June 2025. And before joining RTM Nagpur University, Dr. Payal Thaorey was working as assistant professor of law at Department of Law, Pune University. Madam Payal has a vast academic experience of more than 15 years in teaching and research. Talking about her academic excellence, Dr. Payal Thaorey secured first rank in the Order of Merit for LLM in Business Law 2004 from RTM Nagpur, and also she has secured 8th rank in the Order of Merit for LLB 2002 from RTM Nagpur University. Her doctoral thesis was on critical analysis of cyber laws with special reference to cyber crimes. And she got the PhD from RTM Nagpur University under the supervision of Dr. Triti D. Patel, then Faculty of Law, RTM Nagpur University. Dr. Payal is also the member of the Senate, RTM Nagpur University since 2022 and will continue till 2027. Madam has also remained as the chairman of the Board of Studies Law, RTM Nagpur University from 2022 to February till August 2023. She is also the coordinator of IPR Cell, RTM Nagpur, and has also received Certificate of Appreciation as Patent Expert from the Innovation Cell of Ministry of Human Resource Development, Government of India for the year 2018-19 for being the active member of RTM Nagpur University's Innovation Cell. If we talk about her expertise in the field of research, Madam had completed international research consultancy project sponsored by RWI Sweden, wherein she was involved in developing e-content for local government professionals for Asia Pacific region. Dr. Payal has also completed fully sponsored international research project from Raoul Wallenberg Institute of Human Rights and Humanitarian Law, Lund, Sweden. Furthermore, she has also completed minor research projects under the University Research Project Scheme of RTM Nagpur University. And nevertheless, Dr. Payal has also completed copyright acts from Berkman Klein Center Harvard Acts from Harvard Law School 2019. And Till that, Dr. Payal has published more than 50 research papers in various reputed journals, including Scopus in Text, CARE UGC CARE Listed, and several other peer-reviewed journals. Madam has also received the Best Research Paper Awards on many occasions as well. Indeed, it is our immense pleasure to have Dr. Payal Thaorey as a resource person today. I believe Madam will surely enlighten us today by throwing lights on the very important topic that she is going to cover today, that is sampling, data collection, and processing. It's over to you, Madam.
Thank you so much, Tapasini. I hope I am audible.
Yes, yes.
Yes, ma'am.
Yeah. Okay. Thank you. Thank you for this, wonderful introduction of mine. At the outset, I would like to extend my thanks to Dr. Sandeep Nagarare, Dr. Vijay Manot, and Dr. Singh for extending this invitation to me for being the resource person for today's session during this certificate course on research methodology. And I I know that you all were delve into Dr. Azim Pathan Khan sir's lecture. So I need to bring you back, towards me, because what I will be discussing today is it's technical. It's not that theoretical what sir was saying. Of course, the topic which has been given to me is sampling, data collection, and data processing. But I will try to justify this topic within this limited span of time which I will be having. But these are very vast topics, I mean, definitely it won't be possible for me to deal in details about so many things. So what I will be doing, I will be focusing more on the sampling and data collection, and then if time permits, we will certainly get into data processing, because now with Google form and everything, data processing becomes little easy. So let us focus more on the part which you as a researcher needs to perform. Okay. I may be, disconnecting this headphone. So because my laptop speaker is not working, just in case if you have any query in between the lecture, just put it in the chat box. And after that, again, I will put it so that I can listen to your queries very well. So till that time, I will be delivering lecture, and whatever questions you have, you can definitely write it down in the chat box. Is my screen visible?
Yes, ma'am.
Yes, ma'am.
Okay. Hmm. Okay. So let us first go with this concept of universe and sample, and okay. As the topic given to me is sampling, so let us first start thinking about what the sample is or how we have to choose the sample. And then accordingly, we will be discussing the other parts of sample, that is like types of sampling and other things. Okay. See, sampling, when I say, is completely technical in nature, because it is not the same for all. The way your topic is designed and the way you deal your topic has the objectives and the research problem, it will create an impact on the type of sampling or the sample size or the sample frame which you will be having. But basically this is the type of thing, like sampling is something which we generally do in non-doctrinal research. We don't go for a sample in doctrinal research. See, there is always a confusion with lot of students ask me is what is quantitative and what is non-doctrinal. So quantitative, of course, it also deals with number, but it is something which researcher himself is or herself is not doing.
It is a data, for example, the data which we get from National Crime Research Bureau, or from WTO, or from WHO, or from any of the organization or government portals which they publish like yearly report, annual report or something. So that data, when we use, is called as quantitative. But when I say that I am into sampling and I am doing my data collection on the basis of sampling, it specifically means that the researcher is putting all the efforts in collecting the data and eventually will be doing the analysis and interpretation of it. So it depends upon the topic which you are taking for your research. And nowadays, of course, doctrinal is a very traditional form of research which is there, but getting into non-doctrinal and that to sampling and survey is a very recent trend of research. You can see number of High Court and Supreme Court judgments now show their reliance, on the data which has been produced by advocates and other organizations. So it's a good practice, if your topic can accommodate such type of non-doctrinal research having the samples. Now what happened? Basically, sampling is something which we consider as a primary form of data. And I hope and I assume that you all are done with, primary and secondary sources of data. But just for your information, the data which we collect with like first hand, by your own, if you are collecting that data, then that is called as primary data. And the theoretical data like books, case laws, judgments, etc., etc., that we consider as the secondary data. I one more thing I forgot to tell you. I belong to law faculty, so probably I will be using more legal examples. I am not aware that many of you might be from non-law background. Just try to correlate with your subject, but I will be more simple in explaining these legal contexts. Now, okay, you see this triangle here. Now, in this triangle, I have given you the things or the ladder, or you can say the hierarchy in which we will be progressing into our research. Now, basically, research is classified into three phases. There is phase one, which we call it as a preliminary phase, wherein we do the homework. Okay, a lot of homework is done, which is required to initiate the research. And then the phase two comes in. So this particular chart, if you see from the point research design, so from research problem till framing of research question, objective and hypothesis is the phase one which we undergo. And from research design, when we actually begin with the action of collecting and processing the data, that is the phase two of the research. And in that phase two, after you finalize the research design, now one mistake which many a time researchers do is that in the research design they tell us that we are doing analytical research design, etc., etc., and then they say that I have a we are going for sampling. So these are two contradictions, so they can never be together. Now if you say that your research is non-doctrinal, then definitely your design has to be either formulative or exploratory, because you are going to know about new thing, or you may be creating some new analysis or new interpretation. If it is analytical, then we have to stick to the doctrinal method. So these are basic techniques actually which we as a researcher should know, that what sort of research designing we are doing, and based on that research designing we have to decide whether your research will have sampling or not. Now suppose if your research is having a topic which is related to exploration, or let us say formulation. For example, if we want to discuss something about implementation of artificial intelligence, or rather application of artificial intelligence in legal education, or in pharmaceutical education, or in scientific education, etc., etc., then this is something which is very new. So here we definitely cannot go with the research design like analytical research research design. Here we have to go with formulative, and if it is a formulative, then definitely there has to be a sample, because we have to work on the primary data which is there. Okay, so first always understand that why we are having a sample in the research. Just for the sake ki, we should have it because others are having it, and we can fill the pages, etc., etc. Don't go with that. Okay, that is not required. We must justify, or there has to be some rationality about why we are going to have sample. And if it is exploratory and formulative, definitely we should go with sample, and vice versa also. Suppose if you write formulative research design or exploratory research design, and if your research does not have sample, then this is again a contradiction. Okay, so make sure that you design your research in such a manner that it justifies the sample. And after you precisely do the research designing, then definitely the next step which comes is the sample selection. Now, what is basically universe? Universe is basically the whole area of your study. Whatever study you are undergoing, whether it is related to AI or domestic violence or, some medical or herbal medicine or something whatsoever. Okay. So the whole area of the study means those stakeholders who are related with that topic. It does not mean the whole population. But suppose if I continue with the example of legal education, then all the law students, the law teachers, lawyers, judges, and to an extent, even the clients also, they all can be the part of this, universe which is there. Fine. So this whole population which is directly or indirectly connected with that topic will become the universe of that research. And what we have to do is, when we are into this process of sampling, is that when we are into this process of sampling, is that we have to make the identifiable group. See, you can never, for example, sometimes we go with this type of classification, male and female. But if your topic is, let us say, if your topic is based upon income, or if your topic is based upon education, then we have to classify the population accordingly, like UG, females who have completed UG, or females who have completed PG, and those who are below UG, So this is how we have to make the identification of the groups, and accordingly we have to create the population. Otherwise, everybody is part and parcel of this particular process. But as a researcher, it becomes very, very difficult. So just randomly, just thinking about all women or all men probably will not help us in providing solution to the exact problem. So small factors, like let us say age group, income, sometimes even caste, sometimes religion, sometimes educational qualification, sometimes their physical disabilities, or some feature which can help us in creating that identification, needs to be used. It's a good practice if we have that type of identifiable group in our research, and that can be considered as the population. Otherwise, we know that, for example, in legal studies, everyone, from the society is part and parcel of it. But that does not justifies the thought that we have to study everyone in this particular research, because we have a limitation. Okay, we cannot continue this research for 10 years or 20 years. We have to submit it within time, and we need to make it very precise. We need to make it very categorical, and for that reason, we have to, as a researcher, complete liberty has been given to you, that you can identify your own population or your own universe. Nobody will come and question that why you choose this or why you chose that. Only thing is that you have to provide a solid rationality, or you can say logical relevance for that particular selection. And at times it can be finite, or at times it can be infinite. It absolutely depends upon your research. For example, if you are doing a research on domestic violence, so today there is a finite number of reported cases which are there. So you can say that, okay, 500 cases I am going to study, but tomorrow you don't know how many more cases will be registered, and that is why it can be infinite also, because you will be studying the new cases as well, or new situations, which has been created for domestic violence. So even that can be studied. So it can be finite, it cannot, or it can be infinite. So we don't need to go with that myth that it has to be finite or infinite. Only thing is ki you should be able to justify the number, like how much number you are taking. So population, basically what happens, population is too large, it's very, very big, and it is practically not possible for the researcher to study this complete population, like complete domestic violence cases or complete legal education system. It is practically not possible. And in order to make this complex situation easy, there is this concept of sampling. Otherwise what happened, we have to deal with this whole brown thing, ये जितने भी लोग दिख रहे हैं हमारा यूनिवर्स, वो हमें पूरा पढ़ना होता है, but वो practically possible नहीं है. And because of that, in research, this particular thing called as sampling has been introduced. Now sampling is basically dependent on something called as element. Element यानी single person of the given population is referred as element. Any one person from that population is the element, and you choose these elements to make your sample frame, and accordingly you decide the sample size. We have to always see, the good practice in sampling is you have to first understand your universe, that who all are my stakeholders. Once you understand the stakeholder, you just verify that, okay, this element is something which I want. Element means these are the characteristics which that person should have, means education or income or whatever, whatever problem you have. For example, if I am studying domestic violence, and if I am taking the sample who is not married, probably that's a wrong thing. Okay, I have to make sure that that person is married. Okay, so marriage becomes a important feature for that element. Otherwise that sample I cannot use. Fine. So we have to, after finalizing the universe, we have to go for the element. Once we understand that this is the element, I have to then think about the sample frame. See, many a times what happened, students, PhD students, I have seen that they come up with the sample of 50 or sample of 100. That will definitely not justify your study, because when we are doing PhD, minimum which is expected is we should have something between 800 to 1000. Is the sample which is expected, because you get a period of minimum 3 years to 5 years in which you have to submit your study. So 50 sample will definitely will not justify the research problem or the research topic which you wish to study. But suppose a student is there, he is doing his PG or her PG, and if she is submitting some socio-legal research or some project or some dissertation, in that case, we can permit with 100 to 150 or at the max 200. So that is the sample frame which we have to identify. And we have to make sure that that sample must reflect or must come from all the elements of the population. It should not go beyond the population. So that is how we have to think about the sample frame. Now, what is a sample? Basically sample is what? It is the smaller version of the population which is manageable. A simple example is like when we cook rice, and then how we check that rice is cooked, we just take a pod of rice and just try to do it. And if one pod, melts in our hand, then we mashes in our hand, then we understand that the rice is cooked. We don't need to do it for every rice, because that sample is enough. Another good example is blood samples which we give in the pathologies. Okay, so that is also a sampling method, wherein complete blood is not taken out, to test what has happened to us, but they just take a small portion of it, and they, it is enough. That small portion helps us to understand that what has exactly happened to the whole body. In similar manner, because we have a huge population who are dealing with this problem or the situation or the concern, whatever which you are going to study, then instead of going and reaching out to each one of them, we select a portion. That portion is the sample, which consists of the elements of the population. And then, because this is a manageable group, I can study this. I cannot go to the whole population. So this is manageable. You can say that it is a subset. By subset, because it carries all the characteristics of the population. Fine. Like if the population is of married women, that this particular sample also has people, who are married women. So this is as simple as that. That instead of studying the whole, I am studying the less part of it. But all these ये जितने भी parts हमने consider किए, they all are representative of the population. Now this is something very important. We cannot go beyond that population. That we have to always keep in mind. Now, why sampling is important? Because when it comes to legal studies, time and again, whether matters related to taxation, matters related to account management, matters related to narcotics and drugs, matters related to criminal investigation. Time and again, the court has emphasized that we want to have a reasonable sample. It cannot be something, which cannot justify the thing, justify the concern which you are raising. So whether it is Kisan Trimbak Kothola's case, where the court has specifically mentioned that strict procedure has to be ascertained, when you want to collect the sample, and based on the sample, that particular result or evidence, or whatever prayer the lawyer is making, that is discussed. Now, this is just a diagrammatic representation of what we do, basically sampling. Sampling is the process wherein we select the sample in order to conduct the study. Means we started from this whole universe, from this whole universe, then we identify the criterias on the basis of which I am going to collect the sample. Okay, then we try to retrieve, कुछ लोगों को हम यहाँ से निकालते हैं, और फिर ये हमारा एक manageable sample बन जाता है, which can be a fractional part of the sample. Usually, in some studies, 1 to 5% is okay, as I already told you. But for example, if someone very recently, we were applying for ANRF project, and in that ANRF project, specifically the Anushodhan agency, they have mentioned that we want minimum 25% of sampling. Now, for example, if I am studying a group of tribals, who are having 1 lakh population, then minimum 25,000 I have to take. So sometimes these type of representation is also mentioned in the research thing. So as an institute, we can also put this thing, how much sampling our students should go with, or if you are doing a PhD, then you yourself can understand that how much is necessary to justify my topic. So that choice lies to you, but it has to be the fractional part of whatever, maybe 1/10 or 1/25 or 1/5, whatever, so that part can be considered as the sample. So this particular process of taking out the sample, from the population is called as sampling. Okay, it is simple basically. Now, there are basically two types of sampling, in every research, whether it is scientific research or whether it is applied research, whatever, there are basically two types of sampling. One is the probability sampling and the other one is the non-probability sampling. Now, what is probability sampling? Probability sampling means there is non-zero chance of being selected. Means everybody has the chance of being selected. From this population, if you see this population, this whole brown, anybody can be selected. It's as simple as that, that there is no criteria or classification. We will be just based on our conditions which we required for that sample. If they fulfill that condition, so anybody from that sample will be selected. So non-zero chance of being selected. But when it comes to non-probability sampling, every member of the population does not have a chance of getting selected. Means he will be selected only if he is fitting into that non-probability criteria. Otherwise, we will not be able to select that particular sample. So we will just discuss this further. Now, the first type is the probability sampling. Now, what is probability sampling? Probability, as I told you, that everybody has a chance of getting selected. So, the very first example is the simple random sampling, or it is the type of the probability sampling, that is simple random sampling. Now, what happens? All of you know that this lottery tickets are there, and then there is this one number which every time they take out, and if that number matches your ticket, then you are the winner. Now what happened, every lottery ticket, you must have seen, it carries number from 0 to 9. So 0 to 9 is the fixed number. It's you can say that it is your population which is there, and out of them any 5 or 6 numbers is selected, and a combination of, like, for example, 3 4 1 7 2 0, something like that, and those numbers which they selected randomly. So there, either there will be some chit in the bowl and you are picking one chit, or then many a times this online games, they do some random spinning and then they select one number. So anything like that can be done, but there is no specific condition as to when and how that number will be selected. It is selected randomly without anything. Only condition is that it belongs to that population. If it belongs to that population, we will be able to select it. Then the second type of probability sampling is systematic sampling. Here we have the choice of choosing every, for example, every kth student, hum jisko kehte hain 10th student from this list. Means we have this whole population, but because the population is very huge, or because they are very diverse in nature, what we do, I don't put any condition on my own. I just say that every 10th person who is coming in this class will be the sample for my research, or every 10th person who is entering the mall will be the sample for my research. So it is as simple as that. Basically here also we have this huge population, but हम क्या करते हैं, उसमें से सिर्फ वो 10th नंबर वाला ही चूज करेंगे, या 5th नंबर का चूज करेंगे, या 4th नंबर.
Ma'am, not audible.
Not audible, ma'am.
Yes, madam is not audible. Hello, madam.
Madam, you are not audible.
Okay. Now I am audible?
Yes, now.
Okay.
Yes.
So, in this particular case, what has happened in state of Haryana versus Unique Farmed Private Limited? This particular company has given pesticide, or you can say fertilizers, to the farmers, and eventually the farmers realized that this is a faulty fertilizer, and because of which a crop damage was there. Now, in this particular case, the court, when the argument was made in the court and the lawyer submitted this systematic sampling, wherein he said that every 10th farm or every 15th farm in that particular state is affected with this. And when they produced the data, the court realized the importance of representative sampling, and they say that it is really crucial for validation of the prosecution, validity of the prosecution, because if everybody is affected, so definitely हम सारे farmers का data तो नहीं रख सकते, but एक reasonable number कि देखिए every 5th या every 10th या every 15th farmer or farmland is affected, then that we will definitely accept in the court of law. So that is the systematic sampling. This is a more
Ma'am, sorry for the disturbance.
Yeah.
Your screen is not visible.
Oh, I think something has happened then. Okay. Is it visible now?
Yes.
Is it visible?
Yes, visible.
Okay. I think I might got disconnected for a few seconds. I don't know. Okay. So that is the systematic sampling. Now, as a researcher, I can always tell you that this method is probably the best method as compared to the simple random sampling or stratified random sampling, because here you get the representation till the end, because you were moving continuously, 5, 10, 15, 20. So you reach to that 100 number as well, because you are taking complete representation. So this is a good method, when you are able to identify the population for your research. After that comes the stratified sampling, means wherein strata basically means group, जहाँ पे हम हमारे population को groups में identify करते, because see, I have given you example that if I want to do some study on the facilities of the hospital, whether they are proper or not, so whether they are as per the need of the patients, etc., etc., and I want to do that study, then definitely my population will be the patients who are coming to that hospital. Okay. And then to an extent, even the family members of that patient. Then if I want to continue with this type of study, then I know if that is a multi-speciality hospital, then there are multiple type of patients who are coming. Some may be with heart disease, some may be with kidney, some may be with some medicinal issues, some may be with eyes, some ortho, etc., etc. And not only that, even their age will vary. Okay. And for that reason, what I can do is I can do a stratified sampling. Stratified sampling means, suppose for orthopedic issues, if daily that hospital is having 50 patients on an average, so I will take 5 patients from ortho. But for eye checkup, if 200 patients are coming, then I have to make sure that I am taking at least 20 patients from that. So this is how I do the stratification, कि जितना जिनका number है उसका 1% I am taking out, and then I am identifying the group. Okay, now these are the people. ये मेरा sample frame हो गया है, और accordingly I am studying. So this is how we have to do the sampling, on the basis of strata or on the basis of group. It can be age, it can be any क्लासिफिकेशन जो भी हमारे इसमें रिसर्च में रहता है. अब एक और चीज, आई थिंक दैट यू मस्ट हैव डन दैट समथिंग कॉल्ड एज कॉन्सेप्ट एंड वेरिएबल. तो जो बेस्ट तरीका होता है ना, कि अभी आप में से किसी को ये कंफ्यूजन हो रहा होगा कि मैडम बार बार बोल रही है कि ये कैसे आइडेंटिफाई करना, एलिमेंट, पॉपुलेशन वगैरह वगैरह या फीचर्स। तो अगर आपको आपके पॉपुलेशन के फीचर्स आइडेंटिफाई करने हैं तो आपको कहाँ कॉन्सेंट्रेट करना पड़ता है? कॉन्सेंट्रेट करना पड़ता है हमारे कॉन्सेप्ट्स और वेरिएबल्स पे कि इफ दिस इज, लेट अस से माय कॉन्सेप्ट इज ह्यूमन राइट एंड माय वेरिएबल इज राइट टू लाइवलीहुड ऑफ दोज पीपल। तो अगर लाइवलीहुड पे आई एम टॉकिंग तो आई हैव टू मेक अ ग्रुप अकॉर्डिंगली, लाइक व्हाट इज द नेचर ऑफ द जॉब, वेदर परमानेंट, डेली वेजेस और कॉन्ट्रैक्चुअल, और व्हाट इज द पे स्केल। सो ये सब क्या रहेगा ना, ये सब ऑटोमेटिकली फीचर्स बन जाते हैं मेरे पॉपुलेशन के। तो बिफोर, एंड दैट्स व्हाई आई सेड कि रिसर्च डिजाइन आपको बनाना है तो डेफिनेटली यू विल बी वर्किंग मोर ऑन कॉन्सेप्ट एंड वेरिएबल। सो कॉन्सेप्ट वेरिएबल पढ़ेंगे, उसके हिसाब से रिसर्च डिजाइन बनाएंगे, फिर हम पॉपुलेशन पे आएंगे और वो पॉपुलेशन के एलिमेंट्स से हम फिर क्या करेंगे, हम प्रोबेबिलिटी सैम्पलिंग पे जाएंगे। तो स्ट्रैटिफिकेशन भी हम कर सकते हैं इफ इट इज पॉसिबल टू ग्रुप। फॉर एग्जाम्पल डोमेस्टिक वायलेंस में है तो मैरिड सिंस 1 year, married since 5 years, marriage after 7 years, okay, because we have a provision till 7 years, so after 7 years, तो ऐसे हम उसको क्या कर सकते हैं, ग्रुप में बाइफरकेट कर सकते हैं। अकॉर्डिंगली वी कैन टेक द सैंपल एंड देन ऑफ कोर्स क्लस्टर सैम्पलिंग। यू नो क्लस्टरिंग मीन्स we choose a cluster. For example, if you want to study some topic wherein you want to see ki how this Jilla Parishad schools or ZP schools are doing or performing well, then definitely it is not possible to study all the schools. So what you can do is you can take one from East Nagpur, one from West Nagpur, one from South Nagpur, one from East Nagpur, and something like that, and then you study. Or if you have number, let us say uh, there are no school in East Nagpur and there are 10 school in West Nagpur. So you can make a cluster ki East and West, and then you are taking 2 or 3 schools, you know, from that cluster. So this is also possible wherein you can do the clustering. For example, if I want to talk about right to livelihood, then I can make a cluster of government employee, contractual employee, daily wages employee, or employees based on like vendors ke through, those who are working. So like that, outsourcing, for example, if you have done some outsourcing, so outsourcing people also who are joining your institution, so you can do a study in that manner wherein हम क्लस्टर बनाते। क्लस्टर का भी मतलब है ग्रुप, जैसे स्ट्रैटा में होता है। ओनली डिफरेंस इज कि strata is divided on the basis of number, cluster is divided on the basis of availability, ki how the things are available. If they are not available, you can combine 2 groups and then you can make a cluster there. Okay, so in these 4 types we can go with the probability sampling, and it is also very very good method, you know. ऐसा नहीं है कि इनमें से कुछ गलत है, बट अगेन एज अ रिसर्चर यू हैव टू मेक श्योर दैट विच टाइप यू वांट टू यूज, और रादर व्हाट इज द नेचर ऑफ योर पॉपुलेशन, हाउ एक्सेसिबल दे आर, एंड अकॉर्डिंगली you can choose any of them. Then the next is non-probability. As I told you, non-probability does not give chance to everybody to get selected. Here it is very very specific. You know, I know that I cannot deal from A to Z. I have a very specific time, a very specific requirement. So I will go with non-probability sampling. Again, you know, I'm telling this thing in bold, italics, underline. As a researcher, it is absolutely your freedom that which method you want to use, whether you want to go with probability or you want to go with non-probability. This is absolutely your choice. Only thing what we have to do is we have to give the justification that why I am choosing non-probability or why I am choosing probability. See, factors like money, time, availability of resources, your expertise. These all can help you in identifying whether you should go for probability or non-probability. दोनों ही methods अच्छे हैं, दोनों ही methods correct है, कोई बड़ा या कोई छोटा ऐसे नहीं है. It depends upon the researcher and his or her topic, which type of method you want to choose. Okay, so your choice is there. So do not get confused that which method I want to use. You can use any method, but whatever method you are using, just understand it first, that which type of sample you are taking and why that particular type is necessary. इसका आपको पहले पढ़ाई करके रखना है. फाइन. सो नॉन प्रोबेबिलिटी सैम्पलिंग कौन सा होता है? सबसे पहला नॉन प्रोबेबिलिटी सैम्पलिंग है कन्वीनियंस सैम्पलिंग. कन्वीनियंस मीन्स जैसे यू आर सिटिंग एट वन प्लेस एंड यू आर सेइंग कि पहले 25 लोग जो आएंगे दे विल बी माय सैंपल. सो यू आर जस्ट टेकिंग सैंपल, यू आर नॉट थिंकिंग अबाउट केथ एलिमेंट की पहले 5 फिर 10 फिर 15. नो, यू आर सेइंग कि आई वांट 25, फर्स्ट कम फर्स्ट सर्व, आई एम टेकिंग माय दिस थिंग. या फिर आप फॉर एग्जाम्पल देर इज एन एग्जीबिशन इन द सिटी और हम एग्जीबिशन देखने जाते हैं तो हम कैसे अपने टाइम से जाते हैं, हम ऐसे सुबह 10 बजे नहीं चले जाते. एंड देन देर विल बी समवन हु इज कमिंग एंड आस्किंग यू कि हाउ डू यू फील अबाउट दिस एग्जीबिशन, एंड देन यू आर टेलिंग कि ओके आई लाइक दिस, आई लाइक दैट, वॉट एवर. सो यहाँ पे क्या हो रहा है ना, कन्वीनियंस सैम्पलिंग हो रहा है कि वो 10 बजे जो लोग आए, दे आर नॉट आस्किंग देम, दे आर आस्किंग एज एंड व्हेन पीपल आर कमिंग एंड गिविंग देयर रिव्यू. सो दैट इज द convenience sampling which is there. Judgmental or purposive sampling भी होता है, that you purposefully select some expert. Now here the best example is what Sandeep sir has done. Sandeep sir has collected a sample for this sample of resource person, because there, see, if we categorize population of resource person in India for research methodology, probably we can get thousands and thousands of teacher, but Sandeep sir wanted only 30. So what he did, he just went with the judgmental or purposive sampling, wherein he selected the experts from particular specialization or particular study, and then to an extent I think he might have also applied some convenience sampling, that these are reachable, like whom I can talk, and these are not, because I don't know these people, I don't have their numbers. So best example of how the research person have been selected. So judgmental or you can say purposive sampling is there. Then the third is the non snowball sampling. Snowball sampling basically means see, इसके पीछे का आइडिया है कि स्नोबॉल कैसे गोल गोल घूमता है ना. इट्स लाइक इफ अ स्नोबॉल इज देयर एंड इफ यू थ्रो इट विल मूव. सो इन द सिमिलर मैनर दीज आर द सैंपल्स हु आर देयर ऑन सर्कुलर बेसिस, जनरली जो क्लिनिकल ट्रायल्स के लिए होते हैं या जैसे रेफ्यूजीज के लिए भी होते हैं, या फॉर एग्जाम्पल वन फेज ऑफ रिसर्च इज डन ऑन सम सैंपल, और हम अगर सेकेंड फेज भी कुछ कर रहे हैं उसका एक्सटेंशन, तो हम उन्हीं सैंपल्स पे करते हैं. अगर आपको एक टाइप का मेडिसिन क्लिनिकल ट्रायल में दिया हुआ है तो फिर आप ही के ऊपर सेकेंड ट्रायल भी होगा. व्हाई? बिकॉज दैट इज व्हाट इज द रिक्वायरमेंट हियर. अदर पीपल, दोज हु हैव नॉट अंडरगॉन द फर्स्ट फेज ऑफ रिसर्च, will not become part of this research, and that's why this is non-probability, and this mainly requires in scientific researches. And then there is quota sampling, 50 males, 50 females, I want this representation. So our reservation policy is the best example of quota system, wherein we make sure that everybody is represented. Fine. And then the last is self-selection sampling. Now this is again at some time, researcher with their own skills, their own specialities and expertise, they have this intuition. I want this sample, or I want to interview this person, or I want to take review from this person, or I want to ask information from this person. So that also you can do, wherein you are using your intuitions with which you are collecting the sample. Another thing with self-selection is, like, suppose I give you example here, that if you are opening a website, and those people who are coming to your website will definitely fill that survey form or Google form or information form, whatsoever it is. So that will also become a self-selection sampling, wherein the sample themselves is coming to you. That, okay, I am joining your website, or I am going through your website, and I will fill this form. So even this is possible. So whether it is probability or whether it is non-probability, it does not matter. What matter is according to what factor you have chosen this population, how much sample you have taken. It has to be justified, means based on percentage, it has to be there. And if I have understood the sample, then what method of sampling will be best feasible or best applicable in my research. Okay, so based on that, you have to collect the sample. Fine. Is this okay with sampling? So that we can quickly move on to the next topic, and that
Yes, sir.
is that is um, that is the where, okay, I know that I have very less time, and I'm just trying to be very quick with the topic. My PPT. If you have any queries about this, you can definitely okay. Yeah. If you have any queries with this, please write it down in the chat box so that we can discuss. I hope this screen is visible.
Yes, ma'am.
Okay, fine. Okay, so this is the next topic for the day, that is the method of data collection. Now, once we identify that we are into this sampling method and we are going to collect the data for a non-doctrinal research, then the next step which comes to you is the method of data collection. यानी अभी हमने सैंपल आइडेंटिफाई कर लिया है, सैम्पलिंग टेक्निक भी हमने आइडेंटिफाई कर लिया है, और अब हम क्या कर रहे हैं ना, अब हम सोच रहे हैं कि ये जो सैंपल हमने सिलेक्ट किया है हमारे सैंपल फ्रेम के अनुसार, सो विच मेथड इज बेस्ट suited for collecting the primary data. Prima facie, these are the three methods which we use for collecting the data, that is the questionnaire, the interview, and the observation. But along with that, sometimes the surveys or even the case studies will also help us in generating the primary data. Okay. Now, data collection, can you see these two ladies, in this picture? So what they are doing, basically, they are talking. And in our Indian, this thing, it has been said that, they are not just talking, but they are trying to collect lot of information कि आपके नेबरहुड में क्या हो रहा है, मेरे नेबरहुड में क्या हो रहा है, फिर मैंने कल ये देखा, फिर आपने कुछ और देखा क्या. And then what they are doing, basically, they are exchanging their information which is coming down, or we can say that we are creating a data. Now the same thing, when we are into this process of data collection, what basically we do is we gather and then we measure the information on the basis of variables of interest in a very systematic fashion. Now, what this picture depicts is a very informal way of data collection. One person is collecting information from other, but this is informal. But because we are doing research, okay, which is very, very formal way of generation of knowledge, or you can say creation of knowledge, it has to be very systematic and done in a very desired manner. See, in any research, if if you just say that, okay, I heard that this is there, or I assume that this was like this, that is not accepted. We need some validation that this many percentage of samples have given us this data, or the survey shows this data, or the questionnaire reflects the data, then and then only it will be valid. And again, this data collection has to be with research, in tune with research question, hypothesis, and what are the objectives which we want to achieve. So basically, problem rational objectives क्या होते हैं ना, वो हमारा ट्रैक होता है, जिसको हमें हमेशा पकड़ के रखना पड़ता है. We just cannot go here and there. So for data collection also that applies. Now, if let us not go into the details of the meaning of it, just understand, कि हम basically इसमें करते क्या है. Maximum, जैसे theoretical data जब हम collect करते हैं ना, जिसको हम doctrinal में कहते हैं या library based कहते हैं, वहां पे हमारे पास choices बहुत ज्यादा होते हैं. Probably you will be having, let us say, hundreds of authors, thousands of case laws, on the basis of which you will be doing that particular research. But यहाँ पे जब हम primary sources की बात करते हैं, तो वहां पे हम क्या करते हैं ना, we look for more accuracy and we look for more honest data, because that we cannot deal any sort of manipulated data in the research. If your data is manipulated, then definitely the results will also be manipulated. And believe me, if the result is manipulated, there is absolutely neither there is job satisfaction, but there is also no need for this particular research. And means many a times it happens that we started with a very manipulative thought of carrying out a research, but eventually when we get into this process, now this is the most action oriented process of the complete research, then definitely we try to understand what is the reality, and then you see the realistic situation, and then definitely we feel that, okay, no, this is now something good which is happening in the research. So always look for that type of data, which gives you more accuracy, and it has to be a very honest and unbiased way of collection. See, your sample can be judgmental, but your way of collecting those people, और उनके व्यूज को आपको मैनिपुलेट नहीं करना है. आप जजमेंटल होके सैंपल ले सकते हो, बट वो सैंपल जो भी कुछ बोल रहा है उसको हम वी कैन नॉट मैनिपुलेट. सो वी नीड टू शो ऑनेस्टी देयर, एंड दैट इज हाउ we need to go for the data collection. Now, what is the requirement for data collection is basically appropriate data collection instruments को use करना है, and instructions जो भी देना है वो correct देना है जिनसे भी आप data receive कर रहे हो, so that chances of errors are less. Because I have seen this, in so many years, I have seen this, that if you collect the data of 20 people, then at least 7 to 8 people will give incomplete information or wrong questionnaires, or probably whatever information they are producing in that questionnaire is not worthy enough, to be considered as data. Okay, and for that reason, we have to make sure that while collecting data, we should be doing the exact this thing. One more thing, Tapasini madam, just let me know when I have to stop, because I am also continuing and I think I am also superseding your time limit. Please let me know when I have to stop.
Not actually, madam. You are the last resource person. You can take your time, madam.
So I have another 5 minutes or 10 minutes?
More than that.
Madam.
Okay, fine. Thank you, madam. So when we say that we are going to collect the primary data, then I already give you that these are the lists. See, you can choose any method from this. Either it is questionnaire, interview. Focus group interviews are a new, very trendy thing, which nowadays at lot of international forums, they are using focus interview groups rather than going for interview of one single person. Then observation is a method. Okay, one more thing I want to tell you is that whenever we are doing a research with children, person below the age of 18, या disabled या victims या suppose if you are doing some study with prisoners or something, go with observation method, because we cannot ask directly, like we cannot ask questions directly to children or senior citizen, या for that matter जैसे कोई पेशेंट्स होते हैं जो मूव नहीं कर सकते या जिनके कुछ लिमिटेशंस होते हैं, तो वहां पे ऑब्जर्वेशनल स्टडीज आर द बेस्ट स्टडीज. तो अगेन आपको देखना है, अगर फॉर एग्जाम्पल if I want to do some study with tribals, तो definitely I will go with survey, because questionnaire ना मैं उनकी लैंग्वेज में कम्युनिकेट कर सकती हूँ, ना वो मेरी लैंग्वेज समझ सकते हैं, तो वो आउटराइटली रॉन्ग मेथड हो जाता है वहां पे. तो वहां हम सर्वे मेथड कर सकते हैं. बट सपोज इफ यू आर डूइंग, लेट अस से आई एम वांट टू स्टडी सम डिस्प्लेसमेंट ऑफ द पीपल बिलोंगिंग टू दिस पर्टिकुलर रीजन ड्यू टू माइंस, ठीक है, तो वहां पे मुझे केस स्टडी करना है. सिमिलरली डायरीज, यानी अगर आप हिस्टोरिकल स्टडीज कुछ कर रहे हो, फॉर एग्जाम्पल इफ यू वांट टू डू सम स्टडी ऑन शिवाजी महाराज इंटरनेशनल अप्रोच और मैरी टाइम अप्रोच अगर कुछ पढ़ते, तो डायरीज पढ़िए, यानी जिन्होंने जिन्होंने भी उनके बारे में ऑलरेडी रिसर्च किया है, उनके ऑब्जर्वेशंस को पढ़ के यू कैन प्रोसीड विथ योर रिसर्च. और प्रोसेस एनालिसिस की, इफ देर इज अ process which is going on, and every day you are going and noting down that what is happening, how things are changing, and then you are producing a data, so that is a process analysis. Similarly, link analysis means you are connecting one point with the other and then the other point with the third. ये link analysis mostly scientific studies में use करते हैं. I am not from science background, but what I understand is they do वन केमिकल विद द अदर केमिकल, इसका पहले पढ़ते हैं. जब ये दोनों का स्टडी होता है, तो इन दोनों के ऊपर तीसरा केमिकल का स्टडी करेंगे, फिर 3 केमिकल्स का हो जाएगा, तो फिर चौथा केमिकल उसमें ऐड करेंगे. सो दे ट्राई टू एस्टैब्लिश लिंक एनालिसिस हियर. और फॉर दैट मैटर एनी अदर स्टैटिस्टिकल मेथड्स जो भी बहुत सारे जैसे चाई स्क्वायर ये वगैरह होते हैं ना, तो आप इनमें से कुछ भी यूज कर सकते हैं बेस्ड ऑन योर रिसर्च. Nowadays there are lot of technical assistance also which is available to do any of these researches. तो और कुछ कुछ इंटरनेशनल प्रोजेक्ट्स में ना, दे कॉल फॉर पेपर्स जैसे होता है ना, वैसे कॉल फॉर ऑब्जर्वेशन होता है, कॉल फॉर प्रोसेस एनालिसिस भी होता है, कि दे जस्ट वांट अ ग्रुप ऑफ पीपल टू कंडक्ट दिस पर्टिकुलर स्टडी फॉर देमसेल्फ. सो दैट ऑल्सो वी कैन अंडरटेक. द क्वेश्चनियर एक बहुत इंटरेस्टिंग टूल है फॉर कलेक्टिंग द डेटा. इट इज बेसिकली सिंपल है, इट इज अ सेट ऑफ क्वेश्चंस, बट एक टाइप का क्वेश्चनियर अगर हम बना लेते हैं, तो वो मैक्सिमम लोगों को हम पूछ सकते हैं ना. इसमें टेक्निक क्या है ना, आपको ऑब्जर्व यही करना है कि जहां नंबर इज मोर, यानी अगर आप 200 लोगों का डेटा ले रहे हो, तो वहां पे क्वेश्चनियर से चाहिए. और जहां पे कम लोग होते हैं, जैसे अथॉरिटीज का इंटरव्यू लेना है, या कोई पर्टिकुलर वहां पे एक्सपर्ट है जो इसके बारे में बता सकता है, तो उनका आप इंटरव्यू लीजिए. जहां पे मासेस है, वहां पे गो विथ क्वेश्चनियर. जहां पे 2 3 या 4 या 5 लोग हैं, जैसे जजेस का लेना है, तो वहां पे आप इंटरव्यू टेक्निक में जाइए. तो ये इजी हो जाता है कि विच मेथड टू बी used when. So questionnaire is the most economic method. पहले पहले ना टेलीफोनिक क्वेश्चनेयर भी आते थे, 1 दबाओ 2 दबाओ 4 दबाओ, ऐसे वो आता था. बट nowadays we do this thing very effectively with Google form, and you all must be knowing how to create Google form etc etc. और इसमें क्या होता है ना, स्टैंडर्डाइज आंसर्स होते हैं, तो जिससे मैपिंग करना बहुत इजी हो जाता है कि व्हाट इज द आउटकम. आई हैव मैप्ड दिस आउटकम इन प्रोबेबली 6 or 7 स्टैंडर्डाइज आंसर. इनमें से जो रहेगा वो हमारा आउटकम वहां पे होता है. Now, these are the types of questions: open-ended question, close-ended question. Now, my personal experience and आपको अगर मैं कुछ टिप देना चाहूंगी आज के लेक्चर में, तो go more with close-ended question, because in open-ended question, number one, the respondent is not interested in writing anything for you. and secondly, what they will write, we are not able to read. Number three, there may be grammatical mistake, etc., etc. वो तो जाने दो. उसके बाद वो relevant है कि नहीं वो भी नहीं समझेगा. तो instead of going for open ended, it is always better to go with close ended. Not necessary that you have to give only 4 or 5. You can give them 9 or 10 options as well. Again, bold, italic, underline में मैं आपको बता रही हूँ, क्वेश्चनियर में गलती से भी don't put any yes or no वाला question. Now what happened if the first question they give you yes, second question no, third yes, so इससे कब हम ना मैपिंग ही नहीं कर सकते. So it's a very very bad practice, rather wrong practice, to make the questionnaire with yes or no. और to an extent, I will not even recommend strongly agree, disagree. वो बहुत ही जेनेरिक के लिए है. हम रिसर्च कर रहे हैं ना, तो हमने क्या देना चाहिए. फॉर एग्जाम्पल, इफ डोमेस्टिक वायलेंस इज देयर, देन व्हाट कुड बी द प्रोबेबल रीजंस. जैसे डाउरी मांग रहे हैं, या दे फील दैट फीमेल का फैमिली इज रिच, और दे फील दैट हस्बैंड इज नॉट अर्निंग इनफ टू look after the home, etc. तो ये options आप ही दो, and let people choose out of this option, rather than whether are you came across any domestic violence, yes or no. Now just imagine if the sample selects no, then that particular sample is not worthy for our research. वो हमारे काम का ही नहीं है वहां पे. So it will be scratched at the very first point, and that is why we need to see कि क्लोज एंडेड ही हमें देना है, और वो भी वेल डिजाइंड क्लोज एंडेड क्वेश्चंस आर रिक्वायर्ड. इट कैन बी कॉन्टिन्यूअस, लाइक एक क्वेश्चन का दूसरे या तीसरे क्वेश्चन से होता है. ऑर्डिनल होने चाहिए हमेशा ना. क्वेश्चन का नंबरिंग देना है हमको, या ऑप्शंस का भी नंबर देना, ABCDEFG. डोंट पुट बुलेट्स. ओके, दैट्स अ रॉन्ग प्रैक्टिस यहाँ पे. तो इस तरीके से हमें क्लोज एंडेड क्वेश्चंस को वहां पे रखना है. ओपन एंडेड क्वेश्चन कहाँ पे होना चाहिए, जहां पे हम सजेशंस मांगते हैं. एनी सजेशन यू वुड लाइक टू गिव टू अस, you can put that as an open ended, let them write. See, people are not interested in even responding to questionnaire, but if they so, and if we ask them to write, they will not write. Okay. And questionnaire के साथ एक और चीज होती है कि understand your audience first. Now if your audience does not understand English, then how can you ask them to fill Google form, etc., etc.? Then you have to convert or translate that Google form into Marathi or Hindi or any of the local language which they understand. Then you have to also see that they should have email address so that they can log in, etc., etc., and then they will fill. And if it is not Google form, and if it is hard copy, then you have to make sure that you are going to assist each one of the respondent while they fill the form, so that if they have any confusion or doubt, or they don't know what to write or how to do, sometimes they do unnecessary 2-3 tick marks also, then there is lot of scratching. So if this is there, then that questionnaire is not useful. Now, what could be the sequence of question? Now, this is the thing. First, you have to prepare the screen. Screen preparing, यानी you have to write your name. If your supervisor is there, write their name, write title. Always put a disclaimer that this data will be used only for research and not for any commercial purpose, or it will not be published, in any of the newspaper or anywhere. Before the award of degree, etc., etc., and it will be kept confidential. So that screen you have to create. Number 2, there has to be warm-up questions. Warm-up question means name, place, age, whatever required. If your research deals with religion or caste or income or age, then only put this question, otherwise they are not required. Okay. Or for example, physical disability, if research is around it, then you must ask whether you are a disabled or not, something like that. That question you have to put. We call it as warm-up question. Then you have to do the transitional question. Transitional question mein, again I will be just simply I can tell you, we have to first prepare concept based question, then we have to prepare variable based question. Okay, abhi time itna nahi hai, but maybe next time if we get an opportunity, or maybe some other speaker can deal with it. Concept wale questions banana hai pehle, फिर आपको वेरिएबल्स वाले क्वेश्चन बनाना है, और उसके बाद जो क्वेश्चन रहेंगे ना वो नेक्सस बिटवीन कॉन्सेप्ट एंड वेरिएबल वाले क्वेश्चन बनाना है। ठीक है, कुछ चीजें जो आपके लिमिटेशंस में है उसको आपको स्किप करना है, नहीं तो आपने लिमिटेशन में वो डाल दिया और यहाँ अननेसेसरी उसके क्वेश्चंस डाल रहे हो, तो वो हमें नहीं करना है। वी हैव टू मेक श्योर कि हम उनको वहां पे स्किप करें। डिफिकल्टी लेवल जो रहता है ना, इट शुड नॉट बी वेरी डिफिकल्ट क्वेश्चन। बेसिकली पैराग्राफ वाला क्वेश्चन नहीं लिखना है। व्हाट सॉर्ट ऑफ क्वेश्चन इज रिक्वायर? वन सेंटेंस, सो दैट इजी टू रीड, इजी टू अंडरस्टैंड एंड इजी टू रिस्पॉन्ड। नहीं तो आप 3-4 लाइन वाला क्वेश्चन लिख रहे हो, रिस्पोंडेंट को कोई इंटरेस्ट नहीं है उतना पढ़ने में। सो डिफिकल्टी लेवल एकदम मिनिमम रखने का है। एंड how you are going to change from one question to another question, connectivity होना चाहिए, no changing formula कि from a very basic question to the high level question। शुरू में ही high level question पूछेंगे तो वो respond नहीं करेंगे। So go gradually। Again one more thing, not more than 15 to 20 question, 20 is the limit। okay, इससे ज्यादा questions हमारे questionnaire में नहीं होने चाहिए। Second thing is interview technique. There is one interviewer and then the one interviewee who is there, who just respond to your questions. Okay, so this is the process of interview। इंटरव्यू दो टाइप का होता है, फॉर्मल और इनफॉर्मल। फॉर्मल में स्ट्रक्चर्ड होता है, सेमी स्ट्रक्चर्ड होता है, अनस्ट्रक्चर्ड होता है। यू मस्ट हैव सीन लॉट ऑफ पॉडकास्ट वगैरह, सो दे ऑल आर इनफॉर्मल interviews। But suppose if a authority is giving some interview, if you are going to ask some input from the municipal commissioner or divisional commissioner or collector, so it becomes a formal interview। but at times you are just randomly sitting somewhere and you are meeting someone coincidentally and you are asking them something, then it becomes an informal interview। okay, so you can choose any of the path, but I will suggest कि if you are into a PhD, go with the formal structure of interview rather than the informal one। Now this is how we have to prepare an interview schedule। अब बोल्ड इटैलिक्स अंडरलाइन में ये लिख लेना है हमको कि इंटरव्यू स्केड्यूल के जो क्वेश्चंस होते हैं वो हमेशा ओपन एंडेड अगर रहेंगे तो ज्यादा बेटर रहेगा। बट कभी कभी अगर आपको ऐसे लगता है कि अथॉरिटीज भी स्कैटर्ड हो सकते हैं उनके इंटरव्यू में, जो बहुत बार हम देखते हैं कि होता है, वी स्टार्ट विथ वन पॉइंट एंड देन वी रीच समवेयर एल्स, तो उसको स्ट्रीमलाइन करने के लिए आप वहां पे कुछ कुछ जगह पे एमसीक्यू टाइप क्वेश्चन भी रख सकते हो। या फॉर एग्जांपल, जैसे मैंने कुछ एग्जांपल यहाँ पे दिया है कि हाउ डू यू फील अबाउट पास्ट एक्सपीरियंसेस, और उसके बाद मैं उनको पूछ सकती हूँ कि इफ इट हैपेंड अगेन हाउ वुड यू रिस्पॉन्ड। सो ये मेरा स्केड्यूल में ये रेडी होना चाहिए कि इफ ये आंसर दिया तो ऐसे, या ये आंसर दिया तो मुझे ये पूछना है। तो आपको ये इंटरव्यू स्केड्यूल पहले ही बनाना है। एंड कभी कभी जो रिस्पोंडेंट्स होते हैं यानी इंटरव्यूई जो होता है वो आपको ये मांगेंगे भी कि हमें पहले ही भेज दीजिए व्हाट सॉर्ट ऑफ क्वेश्चंस यू विल बी आस्किंग टू मी। ओके, तो ये हमें एक इंटरव्यू स्केड्यूल प्रिपेयर करके रखना है। Now this is again the template। you can just see opening questions जिसको screening questions भी बोलते हैं, then main body consist of concepts and variable, and then the closing question। like यहाँ पे आप आपके जितने भी concerns है उन्हें आप यहाँ पे डाल सकते हो। टाइम लिमिट अगर देखोगे 30 minutes है, तो this has to be 5 minutes, this has to be 10 to 12 minutes, and the remaining 18 minutes or sorry 15 minutes आपको यहाँ पे देना है, क्योंकि ये हमारे रिसर्च का आउटकम है। तो आउटकम के लिए हमें ज्यादा फोकस करना पड़ता है, तो फोकस मोर ऑन क्लोजिंग क्वेश्चंस। एंड इंटरव्यू के लिए कुछ पॉइंट्स है जो हम इंटरव्यू के वक्त बच्चों को बताते हैं कि हाउ यू शुड गो, हाउ शुड यू प्रिपेयर, एंड व्हाट यू हैव टू शो योर सिंसियरिटी व्हाइल यू आर इनटू द इंटरव्यू, सो दैट द इंटरव्यूअर आल्सो फील दैट ओके आई नीड टू बी मोर सिंसियर इन रिप्लाइंग द responses। दिस इज ऑब्जर्वेशन मेथड. अगेन आई टोल्ड यू, ऑब्जर्वेशन कब करना है? जब हमारा रिस्पोंडेंट रिस्पॉन्ड नहीं कर पाता है या हम उसका रिस्पॉन्स ट्रेस नहीं कर पाते. फॉर एग्जाम्पल, आई वॉन्ट टू सी why people are not following the signals. I cannot go with questionnaire or interview. I have to be observational, that I am standing on the corner of the signal and noting down that when a person crosses the signal in yellow light or in red light and when they are not. Okay, so this is the best way to conduct that particular thing. So observation is very fundamental, but lot of skill is required, you know, on the part of researcher if you are using observation, and it has to be very systematic, and उसका noting down भी जो होगा ना वो बहुत आपको systematically करना है. Now, these are the type of observation. Sometimes it is casual, sometimes natural, sometimes subjective, objective, direct, indirect, then participatory observation, non-participatory, structured, unstructured, controlled, uncontrolled, and sometimes covert and overt type of observation are there. Again, depending upon your type of research, you have to find out which type of observation you will be doing. With this paucity of time, definitely I won't be able to explain you that, but आप आगे पढ़ सकते हो इनके बारे में. I will definitely share my PDF with Sandeep sir, and he can share it with you all so that you can study it more. Again, this is type of the schedule pro forma कि कैसे बनाते हैं हम ऑब्जर्वेशन स्केड्यूल. तो इस तरीके से आपको बनाना है. आप उसमें चेंजेस कर सकते हो अपने अपने रिसर्च प्रॉब्लम्स के अनुसार या रिसर्च ऑब्जेक्टिव्स के अनुसार. Okay, so with this, I finish with data collection, and I think I definitely do not have time for the data processing. So if you have any queries, we can quickly take.
Or anything which you did not understand, you can definitely ask me.
I think there are a few questions in the chat box.
When the research population in certain groups, such sample population is very small, then can we select all sample population or size out of that? We can select it. Definitely, if the sample, population itself is very small, then if it is in your capacity, you can definitely study the complete sample. Absolutely no problem in that. But even in that also, you can make some filtration. So डिपेंडिंग आई सेड ना, रिसर्चर को उतना परमिसिबल होता है कि आप कैसा लॉजिक वहाँ पे एक्सप्लेन करते हो. फॉर एग्जांपल, इफ आई एम डूइंग सम स्टडी बेस्ड ऑन सम पेशेंट सिचुएशन, and if you are doing some
Madam, your voice is too low.
Is it too low? I am speaking with that pace only. Yes, am I audible? Am I audible?
Yes, ma'am. Audible, but no volume.
No volume?
Yeah, please check your connection, madam. Like, we can't hear you clearly. Your voice.
Now can you hear me?
Yes, better. Yeah.
So I think while speaking, I have to be in this way. Fine. So you can use any part of that sample as well. And if the sample is less, you can use the complete sample also. Absolutely no problem in that, but you have to justify. As I was giving example, if you are doing research on some specific type of disease and the problems related to patient, etc., so definitely it will not be possible to even to take the complete sample. Let us say if there are 20 patients, so it might not be possible. So here in that case, you can go with 1 or 2. But when you go with 1 or 2 sample, then what you have to do is you have to make sure that you will be doing the case study. Okay, वहां पे फिर हम क्वेश्चनियर या हम इंटरव्यू शेड्यूल नहीं लगाएंगे. अगर हम 1 या 2 या 3 लोगों तक भी अगर पढ़ते हैं तो हम उसको केस स्टडी कहेंगे. सो वो आपको वहां पे immediately you have to make sure that कौन सा मेथड आप यूज करते हो? आई थिंक निखिल हैज आस्क्ड दिस क्वेश्चन. Which is the best method? BRM has asked. Questionnaire, interview, observation, focus group for legal research in today's scenario. Again, it is a very, very subjective thing because it depends upon what is your topic. Now, I told you that if you are doing a research on tribals, or let us say traditional medicine, or a very grassroots topic, then definitely you cannot go with focused group. You have to go with questionnaire, you have to go with survey method. But suppose if you are going up some, like how smart cities can be made, or what sort of local management or sustainable development goal has to be implemented, definitely we should go with focus group here, because multiple people are required to ponder in their views in order to discuss this topic. So it depends. Every method is the best method. So कोई चीज research में गलत नहीं होती, and that is the beauty of it. It is always the researcher who needs to justify what is good and what is bad. And as per your research and relating to legal research in AI. Okay, for me, I have worked with focus group also. I have worked with, I already told you, we have completed 800 people questionnaire also. I have done case study also, and for tribal studies now I have gave the sample of 25,000 tribals also. So depending upon the topic, I have done lot of permutation and combination in applying this method of data collection. So whatever is best suited to you, your understanding, your topic, you are free to choose. कोई अच्छा बुरा इसमें कुछ नहीं होता है. Okay. Without questionnaire, can we collect data from any other method? Yes, I already gave you a lot of methods. Okay. Interview, survey, diaries. For example, if you want to like historical, so they go with lot of biographies and autobiographies. They study that. It is absolutely possible that what method you are using. And I already told you before we begin for non-doctrinal like this data collection, जो ऑलरेडी पब्लिश्ड रिपोर्ट है ना, जैसे एनसीआरबी का है या किसी भी अथॉरिटी का है जो गवर्नमेंट पोर्टल्स पे अवेलेबल होता है, वो तो हम एज इट इज ले सकते हैं, वो क्वांटिटेटिव डेटा में आता है. ओके, सो दैट विल नॉट बी द प्राइमरी डेटा, बट दैट इज द क्वांटिटेटिव डेटा विच यू कैन यूज. If research is on any topic for a state, then how big would be the research population? I told you it can be in lakhs also, but then you have to justify, what number you want to take, but be very reasonable in it. You cannot be very generous about it, but be reasonable. यानी आप state population पे पढ़ रहे हो, but you cannot go with 5 or 10. But अगर आप let us say state human rights commission पे पढ़ रहे हो, तो स्टेट ह्यूमन राइट्स कमीशन के जो कामों से बेनिफिशियरी है, तो उसका एक लिमिटेड पॉपुलेशन होगा. उन बेनिफिशियरीज में फिर आप क्लासिफिकेशन करके प्रोबेबिलिटी या नॉन प्रोबेबिलिटी ले सकते हो. सो इट डिपेंड्स. एलिमेंट्स बनाइए ना, फीचर्स ऐड करिए. पहले तो फ्लो चार्ट बनाना है. रिसर्च में ना सबसे पहले फ्लो चार्ट बनाना पड़ता है कि व्हाट आई वांट टू अचीव, and accordingly move forward. So phase 1 of research is very, very important. Lot of homework is required, कि हम कैसे justify करें. I think this many question is, thank you for your views. Very informative. Thank you. I hope I have some use in your research. So any other question, I will be very happy to answer. If not, we can wind up. No issues. I don't want to spoil your Sunday. I know it is important. Sunday is important. Oh, thank you. Thank you, sir. Thank you so much.
I think Madam had almost answered all the queries of our participants. Thank you so much, Madam, for your truly enlightening lecture. It was indeed very delightful listening to you. May I now invite Dr. Sandeep Nagarale, sir, to kindly give the vote of thanks.
Yes, thank you, Dr. Tapasini, madam.
Thank you, sir.
So I'm thankful to Dr. Payal Thaorey, madam, for accepting our invitation. And you have provided very deep knowledge with us in respect of sampling and other things. So on behalf of Swatantya Senani Jawaharlal Darda College of Law, Yavatmal and Department of Law, Manipur University, I am thankful to you for your valuable time and accepting our invitation. Thank you. Thank you very much.
So much, sir. Thank you. And I apologize to you all because I have to wind up. The topic was so big.
Yeah, I know you are
Yesterday,
busy somewhere.
no, and yesterday only I called Sandeep sir and said that this is a very big topic and probably I need 1 week more than that to complete this. So I tried my best. But if you have any queries, you can just mail me across anything, if anybody wants any.
Please share your PPT, madam. Then I will
I will share my
share
PDF with
among
you,
you.
sir. Just give me some
Yes,
time.
yes.
Maybe by today evening, I will share. You can please share it with your participants. And
Okay.
also, I can just write down my email address. If anybody has any query, they can directly mail it to me. No issues with that. I am quite good with emailing, so I do respond. So don't worry. I'm just writing down my mail ID. Okay. So thank you so much. I will share my PDF by today evening. Thank you.
Thank you very much, madam. And we also expect you in our next program also. Probably again on research methodology and IPR or other topics.
Yes, sir. At your service. Don't worry. I'm there. Thank you. Thank you so much.
Thank you. Thank you. Yes.
Good day.